So I'll declare this public hearing open, and I'll begin by acknowledging the traditional custodians of the land on which we're all meeting, which is varied across the country, and pay my respects to their elders past and present and emerging. I declare open the public hearing of the Joint Standing Committee on Electoral Matters for its inquiry into the 2022 federal election. In accordance with the committee's resolution of the 2nd of August 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. I remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. I now call on representatives from the Digi Industry Group to give evidence. For the Hansard record, would you please state your full names and the capacity which you appear before the committee?
My name is Dr. Jennifer Duxbury. I appear here representing the Digital Industry Group, Inc. And my role is Director of Policy, Regulatory Affairs and Research.
Thank you.
Thank you, Chair. My name is Sunita Bose. I'm the Managing Director of the Digital Industry Group, or for short.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair, and to committee members for your time today and the opportunity to appear before this inquiry. By way of background, Digi is a non-for-profit industry association that advocates for a thriving digitally enabled economy in Australia where online safety and privacy are protected. That's our vision, and we bring global and Australian technology companies together in that vision. Our founding members are Apple, eBay, Google, Linktree, Meta, TikTok, Snap and Yahoo. And our associate members are Change.org, GoFundMe, productreview.com.au and Redbubble. Digi developed the Australian Code of Practice on Disinformation and Misinformation in conjunction with its signatories to give effect to Australian government policy in this area following the Digital Platforms Inquiry. We launched the code in February 2022. The code has been signed by 8 major technology companies, including the major social media platforms, Adobe, Apple, Google, Microsoft, Meta, Twitter, Redbubble and TikTok are the signatories. Every company that signs the code has agreed to safeguards to protect Australians from harmful disinformation and misinformation online, and that includes commitments to publish and implement policies on their approach and provide their users with means to report content that may violate those policies. They've also agreed to implement a range of scalable measures that reduce the spread and visibility of mis- and disinformation online. Signatories are also committed to publishing annual transparency reports about those safeguards. The first set of reports was released in May 2021 and the second set of reports was released in May 2022. These reports are available for anyone to read on the Digi website. The goal behind these transparency reports is to improve public understanding of these challenges over time and also to provide insights into how platforms are managing dis- and misinformation threats on their services. Digi shares the government's commitment to maintaining electoral integrity, as is evidenced by our work in developing the code, and also our work in developing the Statement of Intent on election working arrangements between the Australian Electoral Commission and major online platforms, which codifies our relevant members' extensive work under the Dis and Misinformation Code and also provides for cooperation on the enforcement of Australian electoral laws and promotion of civic participation and engagement with the election. Digi considers that a multi-stakeholder approach to mis- and disinformation is critical to achieving successful outcomes in this policy arena. Responses should not just focus on online platforms, but also have to acknowledge the role and the contribution of other participants in the ecosystem, including news media, influencers, advertisers and end users. That's really critical if we are to make significant gains in this area. The combination of commitments in the Dis and Misinformation Code means that online platforms subject to the code voluntarily commit to do more about misleading and deceptive political advertising and transparency on their approach to political advertising than is required of traditional media and political advertisers. This does create a gap in regulation, and we consider that carefully crafted truth in political advertising laws that apply to all political advertisers across all forms of media could assist in filling that gap and assist in strengthening regulations that support electoral integrity. That concludes my opening statement, and along with my colleague, Ms Bowes, I look forward to answering your questions.
Thank you.
Chair, my apologies for interrupting. I'll just make a brief comment just to correct the Hansard record that Twitter is also one of Digi's founding members, as well as a signatory to the code of practice that Jenny explained.
Excellent, thank you. You talked about the work digital platforms are doing to combat misinformation and disinformation. Can you talk to us about what you think the scope and impact of that in an electoral sense in Australia is at the moment?
Yeah. Assessing the impact of the efforts of digital platforms is quite a tricky question. I don't think in Digi we're really in a position to make that assessment. We'd probably say that those bodies which are tasked with oversighting the election campaign and enforcement of election laws and are probably best placed to do that. So that would be the Australian Electoral Commission and also the Election Integrity Assurance Task Force. In that respect, I would note that we did get quite a positive review from the AEC in relation to the work and cooperation between that regulator and digital platforms over the election period. And I think we've included some of the examples of that work in our submission, particularly the work that platforms did around boosting civic participation and encouraging users to go to authoritative sources about the election.
And so...
my apologies, Chair. I'll just jump in and just build upon just one point that Jenny made there. That I think this federal election, it's worth noting with the first federal elections that occurred after the introduction of the Australian Code of Practice on Disinformation and Misinformation, which, as Jenny mentioned, was launched in February of 2021. So we, while, as Jenny said, we're not in a position to provide an overarching assessment, we will point to that AEC determination that, you know, this election did see much lower mis and disinformation in other than you know, compared to other like-minded elections across the globe. Yeah, so just worth pointing out that timing, that we think that, you know, that overall would have had a positive impact on it.
And in terms of what your members are seeing in terms of misinformation and disinformation, do you think that there's a potential there for misinformation and disinformation to threaten the running of Australian elections and impact a potential outcome?
I am not aware of evidence to that effect. I mean, we, as I've said, we are very optimistic about the efforts that we've made, particularly in the light of the comments that have been made by the AEC. One other observation that the AEC made, that there was really no evidence of significant foreign interference in the election, and that is often the major source of concern in terms of threats to electoral processes.
Ms. Post, did you want to add to that? And the code is voluntary for your members. What would your view be if measures in the misinformation and disinformation were legislated, if there was a legal requirement on acting in this space?
We don't have a view as to the method of regulation in particular. The Disinformation Code, as you've noted, is a voluntary effort. We put it in place in response to a policy position that was made by government in the wake of the digital platforms inquiry. We have also noted that the ACMA has recommended that it be given powers to make the disinformation a co-regulatory scheme. We're very supportive of that approach as well, were that to come to pass. I think that in thinking about what is the right regulatory approach, it is important to consider that there are obvious differences between those three mechanisms. One of the advantages of a self-regulatory approach is that it is very flexible. So we followed the ACMA's direction in terms of the way that that code was put together. It's an outcomes-based approach, and platforms have flexibility to determine what are the forms of measures that are most appropriate on their very diverse platforms that will enable them to reach those outcomes. That's important in an environment where the tactics and the actors involved in propagating mis and disinformation online can change quite rapidly. On the other hand, in common with many self-regulatory schemes, it does not have the same force as legislation would have. So these are the kinds of considerations that need to be taken into account when thinking about what is the best and most appropriate form of regulation.
And if we were to regulate for truth in political advertising laws, what would that look like, do you think, in the space that you operate in?
We don't have a firm view on exactly what those laws should look like. What I would say, though, is that our experience is that in considering regulation in this area, it's obviously really important to think about the importance of freedom of political communication. So getting a balance right between the level of intervention and political communication is key. So that involves considering, for example, the level of seriousness of misleading and deceptive advertising that should be regulated. I don't think that it would be appropriate, for example, that all false and misleading statements around an election would necessarily be subject to truth and political advertising laws. In the Disinformation and Misinformation Code, we tried to set quite a high standard of harm. So we're looking at regulating types of threats that are serious, very serious threats to political processes.
And if we did have truth in political advertising laws, would your view be that responsibility for compliance would rest or should rest with publishers or with political actors?
I think that it's important that regulation is biting in the place where people are best placed to make an assessment, frankly, about the accuracy and truthfulness of content. So I think that is something that's very hard for advertising service providers to do. I think it really needs to sit with the source of the advertising.
And on digital platforms, what would it look like if we were to regulate in that space? In a practical sense, do your members have a view of what that impact would be on how they operate?
Well, as I said, I think that we would consider that the regulation should probably bite on the advertisers rather on the platforms because they're not best placed to make those sorts of judgments. I don't have a particular view, again, on what those laws would look like. I would, though, say that we would expect that those laws would be fairly general in application so that they wouldn't be confined to the digital environment, that they would apply to all forms of media, offline and online.
Okay, thank you. Senator McGrath, did you have... Oh, sorry, Ms Boast,
my
go
apologies, Chair. I'll just add to the point that Jenny just made there, which is that, you know, we think that these truth and political advertising laws would fill a gap, and we think they're a really important thing, and we're pleased to see the committee is considering it. We think they're best... The truthfulness of a political advertisement is best determined by an independent regulator or a court, rather than advertising service providers, as Jenny mentioned, who really have that sufficient information to assess the accuracy of statements in question. And so we don't have a view as to who that regulator may be, but we do think there should be a level of public transparency around how decisions are made in those determinations, given the importance of you know, political communication in general.
Thank you. I'll pass over. Senator McGrath, did you have questions, or Senator Cadell, are you taking this? You're taking this? Okay.
Note from your submission and your evidence today, your organisation took a large role in the Code of Practice development, and that's going out. And it doesn't currently cover political advertising. Why doesn't the current Code of Practice do that already?
It does cover political advertising to a certain extent. So the way that the code works is that it basically exempts political advertising from being classified as misinformation.
Right.
It doesn't, however, prevent political advertising be treated as disinformation. So, for example, if it was part of a concerted, coordinated, malicious campaign that was being used to inflate a particular issue or manipulate political discourse around an election. So that's the first point. The second point is that political advertising is regulated in a slightly different way, and that was basically in response to the ACMA's position paper that suggested that what was really critical here was that there were measures that dealt with transparency around the source of political advertising. And there is a set of measures in the code and an outcome that is related to that transparency. It's an opt-in commitment because not all of the platforms that are signatories to the code carry political advertising.
Because it's an opt-in, because of all those things, do you think a legislated scheme for publishers would provide greater certainty?
I don't really have an opinion on the form of regulation. I mean, the code does particular things around this area. I think it's doing a good job. There is transparency that is provided by platforms in a number of important ways. Google and Meta in particular provide searchable databases which can be searched by anyone, by the public, and in Meta's case a separate database which is accessible to researchers that does give a level of transparency already.
And through, again, just as advertising and political things move on and change, I think there still isn't a final settlement on where platforms are publishers and what rights they have. We've seen cases recently, Barilaro in New South Wales, Defteros in the High Court, down here with Google. What recourse do you think is the best for me? If I've got a concern about something written about me, I'm not important enough to have anything written about me, but what recourses exist at the moment? What things would you like to see from a current resourcing prevent getting to legal action in these long drawn out processes?
I think in terms of people's concerns about transparency of political advertising, then obviously the platforms do provide mechanisms where people can make complaints. So if you had a complaint, then that would probably be your first port of call in relation to an online advertisement.
Okay. No problem.
May I, Senator, thank you for the question. I'll just jump in here. Look, I think that the question you raise is an important one, but it also relates to different types of content complaints that might transpire on digital platforms. So, there are different complaints avenues for complaints that are in relation to potential defamation, and that can be a different mechanism to raising a complaint around potential misinformation or disinformation. At a general level, where we sit across, we see our members have different, reporting tools that enable the public to identify a range of different types of complaints that they might have on the digital platform, and then they will look at that in relation to their policies and also the applicable laws in that jurisdiction.
It was just Barilaro one was interesting for me because Google withdraw their defences. They put up no defence. They just argued on the merit there, and I think that was a thing where they went through the recourse procedure early. It could have stopped a lot earlier, and I just wanted to see if that was Digi's thing, that the current redress situation was okay given that circumstance.
We wouldn't have a comment on that particular case,
Yeah.
but I will just say that there is a reform process that's underway in relation to the defamation laws that we are closely engaging with.
Okay.
And I think that will go to address, some of the questions that you're raising in terms of these sorts of complaints mechanisms and how you sort of standardise them across the industry to provide records for complainants.
Okay, thank you.
Senator Corrigan?
Thank you. In terms of your code, when you developed it, and did all your founders sign up to it?
No, not all founders are members of are signatories to the code.
And do they have particular issues with it, or is it that they don't see that it's relevant to them? Where I'm trying to go is, if we were to do something and try and roll it out, what would be the challenges we would face, and what would be the objections or concerns that organisations might have in terms of signing up to something?
So in terms of the scope of coverage that is provided by the code, we're very much guided by the ACMA's position paper, and so by and large those companies that have signed the code are those Digi's members that were mentioned by the ACMA, and there are also of course non-Digi members who have signed up to the code as well. And the ACMA has noted in its review of the code that it is quite satisfied about the scope of coverage that is provided and the major digital platforms who have signed up to it.
But if there was a push to sort of extend it, could you anticipate any challenges with that, or anticipate the kind of organisations that would say, well, we don't think we need to sign up to this?
If you're talking about extending the current self-regulatory mechanism, I mean, that's something that we have constantly under review. We are actually going through a review process on the code at the moment, and one of the things that the ACMA has mentioned in its position paper is that perhaps we could consider how we might make the code a little bit more friendly for some of the smaller platforms. So obviously we have quite onerous transparency requirements in there, and one of the things that's been suggested to us is that maybe we might want to moderate that for a smaller category of service, and that would be a way that we could encourage more smaller platforms to sign on. So that is something that is actively under consideration. If there was to be a co-regulatory scheme or legislation, then obviously that would tend to be a broad application.
Senator Grogan, I'll just jump in and add to Jenny's very thorough response there, that it's also worth noting that the ACMA provided a report to government on the code. I believe they completed that report in June of 2021, and it was released in March. And that called for certain powers in terms of the oversight of the code, and I believe one of those powers was around how you potentially direct companies to adopt the code. And so Digi at the time released a media release indicating that in principle we were very supportive of the 5 recommendations that it had, because I think your question is very important. I think we've got these 8 major technology platforms that have signed this code of practice, but I think the better that all of these platforms get, that doesn't mean that all of the disinformation will concentrate on these platforms. It will spill over to others, and I think we've already sort of seen that. So that is, I guess, one of the challenges. As we look at this issue and how we address it in a macro sense.
So, do you have a sense of what might work in theory? So, whether it would be something like a tiered system. And if so, what would you base that on? So, because obviously, as Dr. Duxbury pointed out, the code is quite onerous in terms of transparency. So if you were looking to bring in smaller organisations or smaller providers, then would you see that there was a role for a lighter touch?
Look, it's an issue, as I said, that we currently have under consideration as part of the code review. We haven't actually landed on how we're going to deal with that at the moment. Certainly in terms of how we would classify or categorise different platforms, there is some guidance provided by the ACMA in that respect. They consider that, I think that larger users, larger platforms, I can't remember, Sunita, was it 100,000 users, active account users per month?
I believe the ACMA looked at the ACCC Digital Platforms Inquiry that did set a threshold. I can't remember of what it was. I think it did relate to a certain number of monthly active users. That they considered to be relevant to this code.
So, yeah, sorry, I don't have that information right at my fingertips, but we are considering...
They're up next.
We are considering, obviously, their way of tiering platforms in relation to our response to this issue.
Okay, thank you.
And just, I guess, a bit of a follow-on on what Senator Grogan was trying to get to there on how it applies and who it applies to, on that tension between regulatory versus voluntary environments. I believe the Irish Parliament recently legislated to give their new electoral commissioner the power to compel a social media company to take down misinformation or disinformation within a 4-hour period. Do you think there could be space within Australia's election environment for us to give the AEC these types of regulatory powers to combat misinformation and disinformation?
I think, as I said previously, look, we don't have a particular position on whether legislation or co-regulation or a self-regulatory response is the right mechanism. The only thing that I would say there is that in thinking about misinformation, as I said, it's important to really get the balance right between freedom of expression and the regulation of harmful material, and having transparency around the kind of standard that's being imposed and acted upon. Takedowns are a really important weapon in the arsenal of combating misinformation, but other strategies are also very important. So very often when people talk about what's the appropriate form of regulation, we immediately go to taking material down. I would suggest, and this is very much documented in the transparency report, that consideration be given to the value of a holistic approach. And that's one of the things that we're able to achieve through a self-regulatory mechanism. So other strategies can be quite effective as well. One of them is directing users towards authoritative sources of information. That was something that many of the platforms that are signatories to the code did with great effect during the pandemic, and also as part of their contribution to the recent election. Other strategies include efforts to support digital media literacy and also sometimes deprioritising information or taking steps to prevent that information from going viral are also quite effective.
I might get you to explore a bit more what you're talking about there in terms of providing people with authoritative sources and directing them in that way. Can you step me through how, if you're saying that has worked in the past, how does it work? If I'm deep in the rabbit hole of, the election's stolen and, this is not operated as it should, how does a platform telling me to go elsewhere, how does that operate in taking me out of that rabbit hole?
I think that the strategies that are deployed depend on the different platforms, and I do believe that we've given some examples of how that works on different platforms in the submission. So in some cases, for example, there will be content might be flagged, and you would be directed to a source or a portal which contains relevant information about electoral processes and how to vote and so on.
And do I still see the other content that's popped me down the rabbit hole in the first place?
Are you talking about seeing a particular user-generated post, or
Well,
not quite clear?
Obviously, a lot of what misinformation and disinformation tends to do is silo people in their information. So, everything I've seen about when and how it's effective is when people are not getting a broader perspective, but they are getting perspective from particular sources, and those are the trusted sources for them that are providing misinformation and disinformation. So how does the sort of strategies you're talking about pull someone out of that space?
Okay, I just want to make an important point here. That is a very common view, that when you go online, you are put in a particular silo, you don't have exposure to other sources of information. the research that we've done actually suggests that Australians, a research that we commissioned from Resolve Strategic and which is published on our website as part of our annual report on dis and misinformation, is actually quite heartening in that respect, because it does show that Australians on the whole, when they're looking for news on important issues such as the election, that they are accessing a wide variety of news sources, and that those news sources are primarily the traditional media sources. We have very low levels of Australians that are accessing those sort of like fringe sites or fringe sources of news information. It's less than 1%. So I think that's really important, because often, research into this area is not necessarily Australian focused either. So that's probably the first point that I would make.
That's really interesting to hear. Thank you. Do you have any research looking at the effect of the tools that you've been describing about redirection and transparency?
The transparency reports have documented in the past the effectiveness of these different types of tools and tactics that they have implemented to direct Australians to those sources of information, and they've provided statistics about the number of people that have, when prompted, accessed those authoritative sources. We don't yet have full details of that in relation to the election campaign. Some of that information, as I said, is mentioned in our submission, and some of those particular strategies. And I would anticipate that more information will be available publicly on that issue when the next set of transparency reports are published in May next year.
Okay, thank you.
Chair, Anita here. I'll just supplement Jenny's response to your question, and just to draw out a few details about the transparency reports. I think to your previous point around the types of interventions, one of the things that we have observed in looking at now 2 sets of transparency reports is really that the responses that platforms have are multi-pronged, and that's sort of something that speaks to also our design of the code, where, as Jenny said, just focusing on takedown wouldn't be enough, but also looking at how you direct users to authoritative content, how you educate them. And so, as one of the examples, Apple News created a COVID hub for critical official information in Australia, including a state breakdown of COVID restrictions, case numbers, and ABC content. And that, I believe in their report, they indicated was visited by more than 50,000 readers per day and 1.4 million in total. And then similarly, we've got lots of data on these transparency reports that indicate the volume of content takedowns that they're doing, which arguably is complementary to that effort as well. So Google removed 5,000 videos uploaded from IP addresses from Australia, having content that was dangerous or misleading COVID-19 information. So we are sort of seeing the volume of that. The other point I'll make is that we are trying to drive improvements to that transparency reporting process. Earlier this year, we had an independent expert, Hal Crawford, create best practice reporting guidelines, and he's really encouraging in those guidelines, he's encouraging signatories to look at the same metrics year on year in order to sort of see how their interventions are affecting some of the data that they're seeing. So we really see the role of these transparency reports in ensuring that not only is there public transparency, but it also provides that incentive for the monitoring of interventions to really understand their efficacy.
So you'd be looking, what you're saying essentially is we need to wait for more long-term data to see if these are effective. Is that, yeah.
That's right. So one of the things he's encouraging is signatories to look at this, I believe, potentially across a 3-year period, and to see how things shift. I mean, having said that, I think it's going to be challenging, right? Because, the last set of reports we had were 2021 calendar year reports. So obviously there was a lot of focus on COVID-19 misinformation. As Danny alluded to, the next set of reports will cover the federal election. So each year will be different issues. So I'm not going to oversimplify the challenge of trying to compare those metrics, but I think the incentive to have that transparency and the encouragement through the code to really consider the effectiveness, which I will say, it's not just the code that's encouraging people, companies to do that. I think a lot of the larger platforms do have a lot of rigorous assessment of their data in place already, but the code provides that incentive to make that more publicly transparent to the Australian public.
Thanks. Senator Goodell, did you have some more questions?
Yeah, just that research by Jim Reid and Resolve, that's publicly available? We can go
It
and
is, yes. It's on the Digi website. It was published as part of our annual report on the code.
Okay. Does that dig down to different platforms, different users, their direction? Because there has been a feeling, anecdotally, obviously, that this would go somewhere, that people use a lot of social, use a lot of these things to validate, not inform anymore. So if I believe that, Elvis wasn't dead and he's raising trotters with Bruce Lee out of Tamworth, if I search hard enough, I'll find a site that validates that there. You're saying, but different platforms, does it break down that 1% of, reliable media use? Does it break down Facebook, Google, all those things? Does it go that deep?
No, but it breaks down different categories of media. And so I'd ask questions, for example, what's the source that you go to, and ask people to kind of rank those sources.
Okay. And when last question, more important, but on this one, you talked about it being a multi-stakeholder, social media, digital platforms, multi-stakeholder. And that's what makes it different. Political parties and upfront, we're the low-hanging fruit. We're accountable, we're there, we're easy. But when you've got bots, where you've got foreign actors, where you've got deep fakes and all these things, it's sort of like nailing jelly to the wall, isn't it? It's really hard to keep up if we're not active and agile on the different ways people can misinform.
Look, I'd absolutely agree with that, and that is, as I said, one of the advantages of the self-regulatory mechanism, because we have these high-level outcomes, and then we're able to evolve the measures to respond to the challenges as they evolve over time. So, for example, as you point out, one of the challenges is the use of AI technology to manipulate political discourse. And I understand that disinformation campaigns are available for sale by companies on the dark web, for example. And so the rise of that sort of phenomenon is something that needs a fairly swift response, and that's where a self-regulatory code has been quite useful, I think.
And so that's the final point. What would Digi's preferred platform for dealing with this and the speed? Would it be legislation, or would it be an improved code of practice with self-regulation?
As I said, look, we don't have a particular viewpoint on that. I mean, the code was developed in response to a government policy position. We worked closely with the regulator and took into account the regulator's positions in developing the code. The code is currently under review. We are supportive of previous recommendations that the ACMA be given power if it chooses to make this a co-regulatory scheme. Legislation is something that is obviously something for you to consider, and really there's not anything more that I can add to that.
Okay.
Senator, I'll just add, it wasn't clear to me in your question whether you were asking about digital platforms specifically or disinformation more broadly. And I think the point that I would make here, which I think you touched upon in the premise of your question, is that the information ecosystem is complex and there are lots of different actors. So obviously digital platforms have a role to play. Our previous research that we have done has also shown the complex interplay between digital platforms and traditional media. Obviously, we're also talking about political actors here. As Jenny mentioned, there are companies on the dark web that can sell disinformation campaigns. So any comprehensive policy approach to misinformation and disinformation needs to look at every cog in that wheel and look at whether we've got effective strategies in place. And so obviously Digi, as the organisation that developed the Australian Code of Practice on Disinformation and Misinformation and oversees it, our role is to really ensure that the mechanism that we have in place for digital platforms is strong and responsive. But I think it's really important that this inquiry is looking at the other elements of that information ecosystem and considering where there might be gaps. And that's why, as we, indicate in our submission that we do think the truth in political advertising laws is a gap that needs further examination.
All right. Thank you. Senator Waters, did you have some questions?
Yes, please. Thanks, Chair. And hi to our witnesses, and please accept my apologies that I've missed much of your testimony this morning. I I won't bore you with the reasons, but thanks for your time so far, and forgive me if I'm about to ask questions which may well have already been covered. I'll go back and read the Hansard of the evidence you've given at a later period. So can I start off with the most recent election? Are you across how many complaints were received and how many of those resulted in the material being removed under that code that you've developed?
No, we don't have data on the number of complaints that were received by individual platforms, but obviously though across the information that was provided by the AEC on its website about the material that they identified and the steps that were taken to deal with that.
Yes, thank you. Well, we have covered this ground with the AEC, and we'll do that again when they're next before us. Are you aware of whether or not the social media platforms have essentially committed to agree to remove material where the AEC requests them to do so?
I'm not across that level of detail. That's a question I think that's best answered by the platforms.
Yeah, that's fine. Do you have any sense of the average time that it takes material to be removed if it's shown to be mis or disinformation?
I don't, I'm sorry. I think the AEC or the platforms would be best placed to answer that question.
Okay, no worries. Are you in a position to conduct any sort of review of the Code of Practice on Disinformation and Misinformation to assess its effectiveness and any areas for improvement based on its application in the last election?
So we are currently conducting a review of the code, and that review actually commenced just a few weeks after the election concluded. And so it is focused on specific issues that we've identified that need consideration. One of those issues, or some of those issues, do relate on issues that touch on electoral processes, such as the level of harm that is necessary for something to qualify to be dealt with under the code, so the potential harm to political processes. And we are also looking at clarifying how we treat political advertising. Beyond that, there will be a further review of the code that's likely to occur in about 2024, and that'll be another opportunity for further improvements to be made.
Okay. And forgive me if you've already gone over this material, but can you talk a little bit more about the application of the code to political advertising and the scope of that review and what some possible refinements might be?
Yeah, so the code currently treats political advertising slightly differently to, for example, general user-generated content. And one of the reasons for that is that when we were drafting the code, we were conscious of the potential for truth in political advertising laws. And that's an issue that's been floated on various occasions at the Commonwealth level. And we thought that this was an issue that was really best dealt with by Parliament. So as a result of that, we determined that political advertising should not be treated as misinformation for the purposes of the code. However, notwithstanding that, political advertising is treated as disinformation if it's propagated by inauthentic behaviours that seek to manipulate political discourse. Also in line with the ACMA's position paper, we've included a commitment by relevant signatories towards transparency of the source of political advertising.
Yes, and I think we've made some ground on that issue, at least in recent regulatory sense. But and I hope that your assumption that we'll soon have political advertising laws is correct. That's certainly an objective that myself and a number of other folk hold. Can I take you to the survey that Digi commissioned recently? I think I've got here that 79% of participants said that misinformation is impossible to identify and police, and that policy responses should concentrate on coordinated and or political disinformation. Can I get an understanding of what you mean by those terms? And what if it's not coordinated? What if it's just one individual, but that person has a massive following? What would be your proposed response in that situation?
So the Resolve research does find, as you said, that the public has a preference for regulation to concentrate on basically disinformation campaigns and foreign interference. That's a preference that be given priority, and I think that we have to be a little bit cautious about the finding that the public thinks that it's impossible to police, and that is actually noted in the research, because one of the things that we found in the research, and perhaps the most critical finding, was that generally the public just tends to think of misinformation as false statements that are intentionally made. And so when we're thinking about regulating disinformation, I just think we have to be cautious about relying on those findings, because that is not, what our code is attempting to do. We're not attempting to remove or eliminate all false statements online. I think that would be pretty undesirable in a democracy. And so what we are really concerned about are those very serious harms. Some of those are not necessarily visible to the public too. I mean, I think we were talking about the use of bots to artificially inflate public discourse on a particular issue. So the public is not actually able to see that. And we're interested in making sure that the threat that is posed by that sort of activity to political processes is what's in scope of the code.
Senator Waters, I just thank you for the question, and just add that I think the research more broadly, what we were trying to understand is the extent to which Australians' views, whether it be their political views, might influence what they perceive to be misinformation. So I think the research more broadly is actually quite relevant as the committee considers truth in political advertising laws, because as Jenny alluded to, it does speak to the broader challenge that one person's misinformation is another person's truth.
Yeah. Indeed, people of democracy. And the AUC often reminds us of this and the need for people to be armed with the ability to discern the likelihood of something being accurate and to use their own judgment, but based on, a critical view of things rather than a blind acceptance. Look, I don't have any further questions for you, but thank you very much for your work, and I appreciate your time today. Thanks very much, Chair.
Thanks, Senator Waters. I might ask one question about an entirely separate topic, which is something else I imagine we'll hear about today, which is the media blackout period that currently exists and applies to broadcast media, but obviously not a lot of the platforms that you represent. Do you have a view about whether the media blackout period should be changed to either extend to other platforms or be scrapped entirely, as I think will have recommended to us by the Free TV later in the day?
Look, all I would say about that is that before a decision is made about the appropriateness of blackout laws and whether they should be extended, the preliminary issue that needs to be considered is the extent to which they're effective. I don't have any, information or knowledge of any research on that issue, but I think that is really important. Generally speaking, we do think that there should be parity between online and offline regulation of political advertising.
Any further questions?
That's just a good point, because I think it's harder in a social sense, because once again you have so many users at make it bland, you can't stop. That's when the AI and everything could beat around it quite easily just by overwhelming with private comment. Might be harder to enforce in a digital sense. Just the number of outlets.
Yes, absolutely, yeah. Thank you both for appearing today. I think no further questions. Senator Payne, did you have any questions? No, we're clear.
I'm fine, thank you, Chair. Senator Cadell covered most of the issues that I wanted to cover.
Thank you. If the committee has further questions for you, they'll be put to you in writing and you'll be sent a copy of the transcript of your evidence and we'll have an opportunity to request corrections to transcription errors. Thank you again.
Thank you very much.
Thank you.
Thanks. Get some water.
I'm going to do a copy. We are expecting one person online. Thank you. And then we'll start lobbying the joint committees for. Yep. Just a little container of hot water.
Thermos.
You bring our own first. Hopefully they'll start on blackouts.
Sorry?
You're trying to get Jeremy.
Let's wait for the senator to get out to come back before I start us again.
Hopefully that's Jeremy now. There he is. Everything's really interesting. Because obviously we've put in place where he wants nobody else coming up. She's there. Can he see us? He's done that thing with his mouth. Maybe it indicates that he has the thing on his mouth. Maybe that's a smile. Having operated in the South Australian system for a long time. There is nothing you can't do major TV escape from New South Wales to no idea. That's another Karen in South Australia. Yeah. Use the yeah. Yeah, it does definitely shift your behaviours.
Yeah.
You know about Elvis and Bruce Lee, did you?
I was going to raise that with you again, Senator Cadell.
They got one starting in the second at Newcastle on the
We're
week.
still broadcasting. All right. We will resume and I call on representatives from the Australian Communications and Media Authority to give evidence. For the Hansard record, would you please state your full names and the capacity in which you appear before the committee?
Thank you, Chair. Karina Chapman, Deputy Chair.
Rochelle Zernama, Executive Manager of the Content Safeguards Branch.
And on video conference, Jeremy Fenton, Executive Manager, Consumer Consent and Numbers Branch.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair. No, we do not have a statement. We're happy to take questions.
Fantastic. Well, one of the key questions the committee is looking at in the space you operate in is truth in political advertising laws, and so interested in your views on whether you think they're necessary in an Australian electoral context and how they might operate from your point of view.
Thank you, Chair. The ACMA doesn't have a position on whether there should or shouldn't be truth in advertising laws, although we would note that it is a discussion worth having, and if
if that does eventuate, we would like to raise a number of issues that we think would be important in that context. Firstly, the issue of consistency across various forms of media. It'd be essential that it would need to apply quite consistently. We think there'd need to be very clear parameters about how it would work. Questions which would arise could be, does it just apply to truth in advertising in relation to the electoral process, which the AEC covers now? Is it about falsehoods in how the actual election works, its processes, or would it extend to actual false and misleading advertising? Then, and this is something that we're very familiar with in relation to broadcasting investigations, would it relate to purely factual inaccuracies, or would it relate to bias or those type of issues? It'd be extremely tricky, I think, to work through those things, although it could be done. I mean, as we know, hyperbole, exaggeration, opinions, it needs to be very clear about distinguishing between opinions and facts and those type of things. Another thing which would be very important, which I think was mentioned by the previous witness, would be the timeliness. I mean, it would need to be a system that would set up, I guess it would be set up to ramp up during an election process, election period with considerable resources. You would need to be extremely timely. In an election period, an ad, maybe go to air at 6 o'clock at night, and if it's still on air by the next morning, well then arguably there's an issue. And then there would be questions, if it was regulated, how would it be regulated? Would you do it through a self-regulatory scheme, which could be done through the AANA, the Advertising Association? Would it be co-regulatory? Would it be straightened regulation? If it is done by an organisation within government, clearly it would need to be very independent. What powers would it have? Would it have the power to take down? What would be the review rights, the appeal rights? So I don't want to try and, I'm not trying to complicate it, but it would have considerable work to do. But looking at the AEC's process, which I know you're now very familiar with, in relation to how they handled some of the issues during the campaign, is a good example of how you can ramp something up for a period and do things quickly. I mean, they were working quickly during that process. So it's a long-winded answer of saying it's got a lot of issues with it, but it can certainly be addressed.
No, thank you. And I think the committee appreciates that there are a lot of issues, which is why we are trying to flesh some of these out in these hearings, with the idea that what we're hearing from a lot of people is that it's an area that needs some more attention, but making sure that we're dealing with some of these complexities as well. I would be interested, sort of on that basis, in hearing more about your experience as a regulatory body, and you're talking about, applying factual inaccuracies as opposed to statements of opinion and that space. Can you talk us through how that works in the space that you operate in at the moment?
Well, each of the codes that we administer in relation to commercial broadcasting, but also have some role in relation to ABC and SBS, each one of them clearly distinguish between breaches of factual accuracy and questions of distinguishing between opinion and fact. It's a process where, in an investigation, which I might get Rochelle to go through because she's probably sat on these investigations even more than I have, it's a process of analysing the content that's coming to you to determine whether there's factual accuracy, a factual material that has been put, making an expert decision on whether it is actually opinion or whether it's fact, and then really fact-checking, which in the situation that we're in can be quite time-consuming. Would you like to?
Yep, I can add. It is, we have a sort of a fairly rigorous process that we go through to determine whether content is factual material or whether it amounts to commentary or opinion, as Ms Chapman has said. We look at a number of features with that around whether or not you can quantify, whether there are sort of assertions that can be tested and actually checked, or whether they are subjective or open to interpretation, etc. Having said that, even when we go through that process, it can be very tricky to unpack when someone is making an assertion of fact. And also, I think it's fair to say when you get into areas where there is contestability around particular facts, it is particularly difficult to actually come to a decision in some cases about whether something is in fact accurate or not. So it's not a straightforward exercise. We do it, and we do it in relation to all of our investigations, but it is complicated.
It's also made quite tricky by omission of facts. So, yes, you can put some facts on the table and those facts could be accurate, but if you're omitting other facts, it then becomes misleading. And one of the challenges that we then have is that inaccurate because it's misleading, or is it partial? I mean, we do have a situation where sometimes we say, well, because those facts were omitted, well then this has been what in the colloquial terms you'd call a biased portrayal of the information. So it's not straightforward, it's not easy, and making those judgments are hard to do quickly.
Can you give us an indication of the time that it might take you to go through that process?
Goodness me. Yeah.
I guess it depends on the breadth of the content that we're looking at, to be honest. So if it's a fairly, if it's a couple of statements, it wouldn't take too long. I think with us, in our experience, we might look at a whole program. So there might be a number of statements within that program, and it's also about the context and the picture that the viewer or the listener gets at the end of listening to that whole piece. I think it might be more straightforward with shorter bits of content where you have, and less context, to be honest, because then there's less to take into account.
And there are issues for us in relation to our dealings with the broadcaster that we're investigating, where we seek their views on the material, and then when we are proceeding, if we are proceeding down a route towards a breach, we consult with them when we seek their response, which goes to the question where we started in relation to if you're dealing with truth in advertising in the middle of an election campaign, will that person making that decision be required to seek the views of the content creator, or do they make and this comes to issues of timing. So it's quite complex.
It is complex. Adding to our complexity, I'll move on to the issues we were just discussing with Digi around misinformation and disinformation and their code. I know you've got some information in your submission on your interactions with that and how it's working. Can you talk us through how you see that operating at the moment?
Are you talking about the code generally or particularly in relation to political?
In relation to,
political
I guess, the election space, yes.
Well, interestingly, we didn't, during the election period, we didn't actually receive any complaints in relation to, I guess you say, the material that's covered by the code, mis and disinformation. Part of that, I will get to the answer. I mean, part of that may well be that we worked with the AEC Integrity Commission going into the election and actually put on our websites a one-page information sheet which really said, these are the issues that are covered by the code. Truth in advertising is not necessarily covered. These are the things we cover. If you have issues, here are the contact details for each of the members of the code and the platforms. Now, whether that was successful or not, we're not sure, but we certainly didn't. We do know that they did take down some material during the election. You should be aware of YouTube, and I think Twitter did as well. I think it's safe to say that, I think the code, it's interesting that the process of reviewing the political advertising section is underway at the moment. We think it does need some reform. It's quite unclear at the moment. It's quite opaque. Interestingly, what's happened is that we have a very, very broad definition of political advertising in the code right now. It applies to what you would think of as advertising during an election period, advocating for the outcome of an election or for a candidate, but it also covers social issues. So it will cover issues that sit inside and outside the election, which under our definitions, when we get to issues of tagging, we clearly define as political matter as well. But the code review process now seeks to limit that exemption, which we support. We think that's a good idea because that would mean that those issues type-based would then come under the rubric of being regulated as misinformation. Now, that is a positive, that would be a positive development. But I should say, I think that many of the platforms regulate that as misinformation now. And this is where the disconnect is happening between the code and what the platforms are actually doing. Many of them are doing more than what is in the code. Many of them are going beyond what is in the code. But it is very unclear, therefore, the reporting on what is actually happening in relation to the platform's activities during the election, although we haven't seen a report for that period yet on transparency reports that we get, but it is somewhat unclear. That said, you can see from the recent transparency reports and the ones before and the work going into the election that the code, whether it's been the code has made the difference or whether they've done it anyway, there has been action. I mean, the real-time ad libraries of Google and Facebook or Meta are a significant improvement, and you can if you go onto, I went onto it yesterday, you can see all the ads as they're coming up on Meta for the Victorian election. They're there in real time. You can see how much they're spending. You can see which areas they're directed at and how many times they're being delivered. So that has been positive. There's certainly been positive work on the parts of those two. And I only mention those two because they're the two that only really take political advertising. Authorisation of the advertisers, and also, particularly in the case of Google, limitations on the way in which those ads can be directed. So you can't be targeted for your political affiliation, and you can't be targeted on the basis of a third-party database sheet. So there's definitely been improvements, but we do think that the code could be improved in relation to those definitions of political advertising.
And just so I'm very clear on what you're talking about there, you're saying at the moment the code, it's broad enough that if I was running a campaign as a non-political party but running a campaign around
climate change.
That's right. That would be included as, at the moment, under the code as political advertising, and therefore couldn't possibly be dealt with as misinformation under the code.
That's correct. Though in reality, I do think some of the members are treating it as misinformation. That's correct. And then there's an interplay with the tagging rules, which is another element of I call it tagging, I shouldn't, sorry, the transparency provisions within the code. You can opt into that, and that's where the transparency come in. The code, we believe that the code should make all of those issues transparent. It should be transparent in relation to whether you're doing an issues-based campaign on climate change or if you're a candidate. It should be both. And generally speaking, a lot of that is happening now.
Is there a problem in relying on, essentially if you're saying people are going beyond the code already, is there a problem in relying on the goodwill of actors in this space rather than regulation?
There's a problem in a couple of respects. The first problem is that one of the purposes of the code right from the beginning was an attempt to give the community and users confidence in what platforms are doing. And if it's confusing and it doesn't marry up, then there's a problem. And yes, it's good if individual platforms go over and above the code, but the basic problem that is not unique to Australia, it's universal, and it's a particular issue that the EU, for example, is trying to tackle at the moment, is transparency of data on what is actually happening. And this particularly is relevant in relation to things like complaints. Trying to get uniform data which actually makes sense to both users and to us and government about what steps they're taking. You know, for example, how many complaints are you responding to? What are you doing in relation to them? and also data in relation to the impact of what they're doing. The impact of the platform's actions is very opaque, and that is a process of metrics that is happening in the EU at the moment. The EU has just introduced a new code, its second code, and the platforms now have 6 months to put in place processes and then 7 months to start reporting. But as part of that, they're formulating metrics, which we are eagerly watching and discussing with them. So it's a lot of it is about reporting.
And is that in relation to some of the things we were discussing in the last session around how the platforms will try and redirect or provide, show you to alternate sources of information when you say the metrics around that at the moment, those metrics are not being made public, and so the outcomes are unclear.
And how effective is that process?
Yeah. And so the EU is regulating in this space at the moment.
They're certainly looking at the metrics of how they can measure those actions, yes.
Are there regulations we should be looking at here in terms of transparency and data in this space, particularly when it comes to elections?
Interestingly, in relation to the political election advertising, one of the things that the EU has found, the code has found too difficult to tackle at the moment is actually a definition. And they've given them 12 months to come up with a formed definition of exactly what is meant by political and election matter. I think from memory, I need to look it up, I think that the provisions in this code in relation to political advertising are actually quite similar to what we have. They are based around transparency, and a lot of what I keep using Google and Meta because they're the ones relevant here, they're actually doing on an international basis, and Australia is just part of that. And this is one of the things that we always need to remember, that one of the failings or the difficulties that governments have had in relation to understanding what the platforms are doing has been about country-specific data. They have improved, there's no doubt about that. 3 or 4 years ago, when we first started this process, there was just a wholesale worldwide figure of what they were doing. At least there is some breakdown now. So all countries are looking for breakdown of data, which of course in Australia we're smaller, so it's somewhat difficult. But it does mean that we need to have an international approach to a large extent on what the metrics are that they're collecting the data, because let's be realistic, if it can be required, those metrics can be set in the EU, then it is easier for us to get it here.
Okay, thank you. Senator Cadell? Senator Payne, do you have some questions?
I do, thanks, Madam Chair, and can I thank the representatives from ACMA for appearing today and for your submission. And you've covered a number of the issues in your responses to the chair, but I did want to ask you about your statement on page 5 of 6 of your submission, where you talk about the transparency in relation to the removal of political ads on platforms. What do you envisage would make that function better? What should we be doing that is currently not happening?
Thank you, Senator. Well, I think the issue here is that there isn't actually any reporting under the code at this point in time of those removals. We would also suggest that there should probably be some explanation as to the reason for the removal of that content and the basis upon which it was removed. None of that is clear to us at the moment. It's a reporting issue. Now, I understand probably why they're not at this point in time. It may well come through in the next transparency report, but this does appear to be over and above the requirements of the code at the moment. Do you want to add to that?
Yes, I think the point we made is that they did remove some content during the election campaign. Both YouTube or Google and Meta removed content, but it wasn't entirely clear to us why that was removed. We can speculate that it was possibly in violation of both their COVID misinformation policies and or election policies, but I think it would be useful to know if it's being done, on what basis around some of that reporting that they're providing, either through their transparency reports or through the additional commitments that they've made around the source of political advertising.
And essentially, I agree with you. I think it is useful for transparency and for understanding what the obligations or the observations of the obligations require. I'm in a curious position myself where I made a social media post across a number of platforms in relation to the memorial motion or resolution for Her Majesty's passing, only to find it being taken down on Twitter with absolutely no explanation to me whatsoever, and no response from Twitter as to why it's allowed to stand on Facebook or stand on Instagram or LinkedIn or whatever, but had to be taken down on Twitter. One presumes there was a good reason. I think that is something that we should look at in our consideration for this inquiry. In particular, and you may have covered this, but I don't think I heard any previous questions on the Electoral Integrity Assurance Task Force. And so are you actually a formal member of the task force, or do you work with them on an ad hoc basis?
I'll start, and I might throw to my colleague. We worked through our portfolio department, who is a formal member of that task force. But Jeremy, you had direct experience in terms of participation, so I might get you to explain how that worked.
Indeed. As Ms Sanama has said, we were not a formal member. However, we do receive a number of we have a number of data sets that may be of relevance to the work of the task force, including complaints about telemarketing and commercial electronic messages, commonly referred to as spam, where we receive complaints that can concern electoral matters. So those intelligence sources, we analysed those in the 6 weeks leading up to the election and provided de-identified aggregated data about that information to inform the activities of the task force. As well, we provided information for the task force to use publicly about the ACMA's role to inform consumers.
Thanks, Chair.
And Senator, we did have some informal discussions from other parts of the ACMA, namely from some of Ms Inama's staff, in relation to particularly a video that was on Twitter that was subsequently removed by Twitter that the AEC was particularly concerned about in relation to misinformation about the actual electoral process. So there was some informal interaction between us and the task force in relation to some blackout period issues as well. But it was informal.
Thank you. Thanks, Chair.
Thank you. Senator Waters, did you have questions?
Yes, I do. Thanks, Chair, and thanks very much to ACMA and the witnesses for your submission and for being here today. We've covered a lot of the issues that I wanted to ask about, so I've just got a few additional specific questions. You received nearly 10,000 complaints about unsolicited text messages, but clearly political spam messages don't fall within the Spam Act, given that they're not commercial. Do you have a view on whether or not political text messages should in fact be regulated?
The ACMA does not have a particular view. That would be a matter for that would be a policy matter for government. But I think as our submission sets out, the current regulation that applies to telemarketing and commercial electronic messages is generally framed around those communications where they are commercial. Now, there is one exception to that. There is a standard that sets minimum obligations in relation to telemarketing, and that standard also captures research calls, and that would include political polling. That standard sets out obligations around when those calls are may be made in terms of the time periods, and also sets obligations in place around terminating calls upon request and the kind of information that callers must provide within those calls.
Pardon my ignorance, but is there any regulation of political robocalls?
No.
Other than the authorisation requirement that applies?
Not to the best of our knowledge. Under the Australian regulations and laws, generally robocalls are considered voice calls, certainly under the laws that I've just mentioned. And I think the similar approach is taken in terms of the electoral laws.
I just find it ironic that when you're actually asking someone their opinion, you're covered by that Spam Act because of the research definition that you just took us through. But if you're unilaterally just telling them what you think, that you're not covered, that seems to be a bit perverse to me, given that we're meant to be about giving voice to the community and actually listening to them. But thanks for that information. You talked a little bit about truth in advertising laws, and you did sort of address which body you thought might be the most appropriate to potentially administer such a scheme should legislation be developed. I heard reference, I think it might have been from you, Ms Chapman, to AANA, or perhaps a body within government. Is there anything that you wanted to elaborate on in terms of which body you think would be the most appropriate to administer truth in advertising laws? If you've got anything further to add.
Senator, no, I mean, I referred to the AANA because it is a self-regulatory body. I mean, that's the first point to note, which does limit it to some extent. But what's important is that it regulates advertising right across the board. So its provisions relate to wherever your ad is, be it on television, on a sporting ground, in a sporting ground, online, or on a billboard. Now, at the moment, they have false and misleading requirements in their provisions, but a specific exclusion in relation to political advertising. So that is really the only mechanism in Australia at the moment that it deals with all advertising across every form. Certainly, no, we don't have a view on where it would best be placed, but I would suggest that it needs to be probably quite a distinct unit. I mean, the issue is always, is government itself the right party to be doing this? I mean, we are an independent regulator, which puts us in a different situation to, say, a government department, but there is still an issue. There needs to be independence, and there needs to be seen to be independence. These could potentially be extremely contentious decisions. So there is definitely, and I'm sorry, I haven't heard all the evidence. I'm sure this has come up in the past. I think it did yesterday in a slightly different context. I can see that there is a role here for sort of academia and civil society to be involved in these type of issues. But at the end of the day, there's going to have to be buy-in across all political parties probably to make it work. Speaking probably out of turn, my gut tells me that, a pure government regulator, it's It's a very tricky situation. And we would need to get the publishers involved as well, in the sense of, I mean, the publishers are, you know, those outlets that are actually broadcasting them or putting them online. So it may be a multi-pronged approach.
Well, do you think that liability should lie with both the authoriser as well as the publisher, or just one or the other?
Well, I think that the mechanisms to enforce it are probably going to need to sit across both, as they do now. However, it's already been discussed today about the difficulty about the legal definitions between publisher and content creator. That makes it complicated. But at the end of the day, content creators are responsible for their content. But I think that's quite a complex issue. I think it's going to need to sit across both, probably.
And I think it can involve issues of control of that content. You know, who has control of that content, particularly if it gets extended or expanded beyond its initial purpose or context.
I mean, right now,
It's not going to be an easy one, but
the publishers have a legal responsibility. I mean, if you take a television station, they have a legal responsibility of what goes to air as publisher. And I note in their submission that they're saying we shouldn't be the arbiter of truth. And that may well be correct, that decision making, but there is some responsibility that sits on them at the end of the day in relation to actually putting it out there.
yes, agreed. They can't claim to be completely innocent in this scenario. Okay, can I quickly segue now to the complaints you received? You said you received 34 complaints, but then it turned out that only 4 of them were actually broadcast. So I just wanted to understand a little bit more about the nature of those complaints, and in particular whether or not they were screened on catch-up services during the blackout period or broadcast on free-to-air, you know, point of time at watch, whatever the terminology is. Can you talk to us about whether or not you think catch-up services should in fact be covered by the blackout?
Yes, that's correct. So we did receive 34 complaints alleging that there were breaches of the blackout rules. I might come back to whether we think where we think that should go, but Ms. Inama, can you explain what happened in relation to those 34?
Yep. So in relation to each of those 34 complaints, we did a couple of things. We contacted the industry body, Free TV, to see whether they had any insights into what was happening. We also followed up very quickly with each of the 34 complainants and explained to them what the rules were and what they didn't cover. A proportion of those complainants came back to us and said, thanks, I didn't realise that. In that case, I don't have a complaint. Some didn't come back to us at all, and we can only assume that they realised they had seen it online. 4 of those complainants insisted that they had seen it on broadcast television. So in those cases, we followed up directly with all the broadcasters involved, and they obtained their play-out schedules for those broadcasts, and it was confirmed that none of them went to air on a linear broadcast. They had all been streamed on one of the catch-up services. So it appears that people were either confused about what the rules did or said, or thought that they did more than they set out to do. So I think that's probably covers it.
I'd note that and this is in no way judgment, but that the blackout rules have actually been in Australian law. We looked it up in the day before the election. It first came in apparently in the 1942 Broadcasting Act. So they are not a recent phenomenon. But that said, increasingly over the past few elections, it's become more and more apparent that they are problematic, and I think it's safe to say that this one in particular was particularly confusing. This election was particularly confusing for viewers, in that it is often, if you have a smart TV, Do you remember whether you're watching the terrestrial service or the catch-up service? That seems to be where the major issue is. I know that there are other issues that have been raised by Free TV, which have certainly got legitimacy about online and earlier voting and those type of things. So although we wouldn't have a view on whether there should or should not be a blackout prior to the election, we would say that it does need some assistance to make it consistent, in that it is certainly unravelling in the way it is now. And we would suggest that if the Parliament is inclined to continue the blackout, well then it could be extended to the online catch-up, well not necessarily catch-up live streaming or catch-up services of the broadcasters, both radio and television, to make it consistent across both.
Yes, thank you. I think that's a solid submission. Okay, last question from me. Your submission talks about the AEC's active engagement during the election to minimise the spread of disinformation, and they've obviously received quite a lot of kudos and rightly so for their approach. What more do you think should be done to combat disinformation that undermines confidence in election and electoral outcomes?
Are you specifically...
Pretty broad question, but...
Yes.
What further do you think in your scope of responsibility or for others could and should be done?
Well, firstly, I know you refer to disinformation, and I think this is not within our realm, but as I think mentioned by the previous witness and I assume by the AEC, disinformation in relation to the election process appears to have been relatively limited. Misinformation, on the other hand, I think within the realm of our responsibility, we would say an improvement in the code in relation to the definitions of political advertising, tidying up the discrepancies in relation to issues-based advertising, but most importantly, more transparency and reporting on what the platforms in particular are doing. It's not clear at this point in time exactly, and this is in response to Senator Payne, the issue of what has been removed. I think there's still some opaqueness about their actions. They've definitely improved. It does appear that there is a lot more transparency about who is advertising in a political sense, and the advertising logs appear to be very good. So I think reporting is the main issue.
Okay. Would anyone else like to add anything to that?
No, I don't have anything to add to what Ms Chapman said.
Jeremy?
Mr Fenton, you're all good? No? All right. Well, thank you very much to the witnesses for your time today and your expertise, and of course the regulatory functions that you have, and thank you, Chair.
Thank you. Any further questions? Yes, Senator Cadell.
Just, and it might be we'll ask some other people from Free TV and stuff, the process of potentially removing a blackout for catch-up radio, does that mean we'd have to remaster every podcast, every online thing to remove ads that were legally put on, during the election period or prior to that, for that period, for that 3 week days, if we extended the blackout to those services?
That is a question you should ask to Free TV, but what I would say is that my understanding is that I shouldn't have probably said catch up, because I suspect that by the time you catch up you may well be past the 3 day period.
Yeah.
But you're right. But the advertising is live in itself.
Yep.
So it's been inserted in on that day.
No,
so whether you're watching a live program or something from 3 days ago...
You said radio. That was the one that scared me, because radio podcasts are available on demand from before, and they have the ads that were played at the time.
Well, those ads would be... if they're inserted...
Yeah.
If they've been inserted live, well, then that's fine. They can regulate that. But if they're set... That's correct. And they would have to be very careful about putting in an ad which is embedded into the program. It's unlikely it would be done with political advertising.
Okay.
Most advertising is going in live. Even if you're listening to a podcast, that is an ad that is relevant for that moment when you're listening, as opposed to the actual content. And certainly for television, it'll be manageable.
And political parties, political candidates, it's, said previously one man's truth, another man's lie, vice versa. And you spoke about bias, whether it's misinformation or whether it's bias. Almost with everything we say or do, a government or an alternative government, there is an opportunity cost or a consequence to some other group. Isn't virtually everything we say or do during a campaign has a level of bias, speaking to the good points, not necessarily the negative points?
Well, yes. I mean, the job of politicians is to promote their objectives, and this is where it becomes. And I mentioned hyperbole and exaggeration, and selling. It's a marketing. But in relation to selling a product, the AEC looks at whether something is false and misleading, and this gets down to the question of, if you're going to look at truth in advertising, you can look at facts. What is ostensibly a fact, and whether it is correct or not. That is different to selling an issue. I mean, it might be, a stat. I mean, a statistic is one that really can be done.
I was getting to that. Lies, damn lies, and statistics. Yeah, it's can be really problematic. Just for purpose of stuff, if we're looking at Purple Party comes into government, the cash rate was 0.35%. Just say it's now 2.6. It's only an increase of 2.25%. But in advertising terms, I can say it's a 742% increase in interest rates since 742. I can say it's 7 times higher, or I can say it's 2.25% higher. They're the same number being represented, and that's where I just find it really difficult where you can draw the line.
It is complex, and it has issues of the line between the ability of freedom of political communication and all of those issues, and when you move into a situation of falsity. So it's quite complex.
Thank you. Just to follow up on the blackout scenario, given that things have changed quite so much since the 1940s, do you actually see that there's a relevance in the blackout now?
I don't think the ACMA can comment on whether it's. I'm not sure we're even aware of what the original intention was, which may well have changed at this point in time. I mean, it's been government policies across all colours of government for decades that there be a period of no advertising coming in. Certainly, there is an issue if it's not effective, which I think is the situation that we're getting into now. And I guess as elections become more complex and we have less situations where every person is voting on polling day, then it does alter it as well.
Yeah, I think there's been a lot of commentary in the submissions about bringing everyone into line. I wonder if it's actually about just revisiting why we do it. The whole idea of a cooling off period is no longer relevant when you look at postal voting, pre-polling and all of those things. You'd actually have to move your advertising ban out sort of 2.5 weeks.
And online voting and online advertising is relevant right up until, I assume, until 6 p.m. on Saturday night.
Yeah.
I agree. I think they're two issues. One, is it still fit for purpose in terms of what it was meant to do? And two, if it is, then it needs to be more consistently applied, I guess, because there are currently a lot of gaps. So, yeah.
Okay, thank you. And just one other quick question. Going back to the text messages, the SMS, which is obviously a growing area for everyone in terms of advertising and messaging and such like. You received 9,886 complaints about political SMS. 98.5 of those were about one particular SMS campaign, which was United Australia Party. What were the rest? Was it rats and mice? Was there a theme to it?
Mr. Fenton, are you aware?
Yes, I'm happy to speak to that.
Thank you.
Look, I'm not sure I'd use the term rats and mice, but I appreciate it. There was no unified theme in amongst those remaining complaints. and the vast majority of those additional complaints or other complaints we received were also effectively not commercial and, were not taken forward by the ACMA because they weren't within jurisdiction.
Okay. Yeah, the term maybe it was that there wasn't a common theme through them was really what I was looking at. Whether there's a common sense of it just being I don't like people texting me, or whether it was about the messaging, what was actually being said rather than the act of doing it.
Yes, I think it's fair to say that they were about the intrusion on people's privacy that people felt from receiving a text that in the majority of cases they hadn't given consent to.
Okay, thank you.
Thank you. Thank you for your attendance today. If the committee has any further questions, they will be put to you in writing and you'll be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. I'll suspend our hearing until 11 a.m. Thank you. Okay, we'll resume our hearing, and I call upon representatives from the from the News and Media Research Centre to give evidence. For the Hansard record, can you please state your full names and the capacity in which you appear before the committee?
Hi, I'm Kerry McCallum. I'm the Director of the News and Media Research Centre at the University of Canberra.
Hi, my name's Caroline Fisher. I'm a member of the News and Media Research Centre and a co-author of the Digital News Report.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Good morning. As I said, I'm Kerry McCallum. I'm Director of the News and Media Research Centre at the University of Canberra and an author on the Digital News Report 2022. I'd like to thank you for the opportunity to speak to you this morning. The N and MRC, as we refer to ourselves, advances public understanding of the changing media landscape. Our concern is with the impacts of media disruption on news businesses, audiences and democratic processes. Our presentation provides context around the consumption of political news and information in the lead up to the 22 federal election, which was played out in an increasingly fractured and complex media ecology shaped by the rise of digital platforms and a news media under severe economic pressure. These changes impact not only on the quality of news, but people's capacity and willingness to consume political information. There's more information than ever, but it's less vetted and more people are concerned about their exposure to misinformation. So what I want to do today is to provide you with some of the statistics from the Digital News Report 2022, while my colleague Caroline Fisher will report about people's attitudes towards political advertising. So DNR, as we refer to it, is part of a 46-country global annual survey of news consumption, and the University of Canberra is the Australian sponsor. The report is 140 pages long, as you can see, and so I'm not going to give you every fact and figure in it, but would like to highlight some of the most relevant findings about Australians' consumption of and interest in news and politics, and the political orientation of Australian news consumers as context to this 2022 election campaign. When we look at the way Australians consume news, we get a picture of an audience that is suffering news fatigue and actively avoiding the news. Australians are amongst the lightest news consumers in the world, with just 52% consuming news more than once a day. And just to give you a bit of context, the US is the lowest with 48%, but in Sweden, 70% of people consume news more than once a day. However, the picture is complex, so it's worth examining some of the data more closely. Australians, more than other people, consume news out of a sense of civic duty. We are among the most likely in the world to say we use news to keep us informed. And while we're increasingly accessing our news and information from online sources, including social media platforms, the slide away from traditional news sources in Australia isn't as rapid as it is in other countries. Just 19% use social media as their main source of news, whereas 42% still use TV and just 6% use a printed news or newspaper or radio. Importantly, there are significant differences between the way men and women, young and old people access their political news. Women are most likely to say they avoid the news at 70%, and the gender difference is most obvious amongst Gen Y, those who are aged 24 to 40, where only 40% of women say they're very interested in news, whereas 59% of men. Just a few figures about people's interest in news and politics. The first point is we know from the 2021 survey that only 32% told us they had a high interest in news. That's an important point. The first point is that we know that from our 2021 survey that only 32% told us they had a high interest in politics, while 68% had low interest. And in this year's report, we find that just 51 have a high interest in news. Less than half of Australians, 45%, are interested in political news. So just piecing those sort of figures together. Since 2017, there's been an 11% increase in the number of people who say they avoid the news, from 57 to 68. The main reason they avoid the news is too much political and/or, at this stage, coronavirus news. However, the proportion of heavy news consumers remains steady. So there's a good half of the population who regularly use the news more than once a day. But trust in news continues to fall, with 41% saying they trust in news. And added to this picture, 2/3 had little or no awareness of the financial difficulties facing the news media when we asked those questions. A little bit about political orientation and news habits. The first point is that in contrast with academic concern about political polarisation and partisanship, Australians don't perceive their news organisations to be politically polarised. Rather, they see most media as sharing fairly common political views. The audience for the ABC is quite evenly divided across the political orientation. 38% identify as left-wing, 28% as centre and 25% as right. The Age and the Sydney Morning Herald have the biggest audiences identifying as left-wing, while Sky News has the biggest right-wing audience. Online brands tend to be more left-leaning, Crikey and The Guardian at 71% and 63% respectively, while social media audiences on Twitter and Instagram are more left-wing than Facebook or YouTube. So, I'm starting to wrap up now. We also have some data about exposure to mis and disinformation about particular issues. When we asked about COVID-19 misinformation, even though Australians experienced significantly less misinformation about COVID-19 than other people in the world, and that was, we only experienced 59%, whereas 73% was the global average, we are amongst the most concerned about it. So I suppose you'd say there we hold our media to account. Australians are most concerned about misinformation from government, politicians or political parties at 35%, rather than journalists at 14%. We're the most concerned about misinformation via social media, particularly Facebook. Older generations tell us they want impartial, neutral and balanced news. Well, all generations tell us that, but older people in particular. But young people also want journalists to take a position on issues such as climate change. So, to conclude, how does this help us to understand what was going on in the lead up to the 22 election? In January and February 2022, as Australians got ready to go to the polls, trust and interest in both news and politics were relatively low. Trust in news is closely associated with trust in public institutions. So Australia's low interest in and active avoidance of political news, coupled with a shift away from traditional news sources and a deep concern about the amount of misinformation should be a cause of concern for government and political parties. So I'd now like to hand over to my colleague, Dr. Caroline Fisher, who'll share findings from our research about people's attitudes towards political advertising.
Thanks, Kerry. Hi. Yes, I'm Caroline Fisher. So the report you've got in front of you is from this year, from 2022, but we've been doing this for 7 years now. So the report that we did in 2020 asked questions specifically about attitudes to political advertising generally, as well as false political advertising specifically. And what we found in our 2020 report was that there's more support for political advertising on traditional news platforms, such as TV, than on digital platforms, such as social media. Half of Australians thought politicians should be able to advertise on television, compared to roughly 1/3 who said political advertising was okay on Facebook, Twitter and Google, for instance. Gen Z were more supportive of political ads on social media compared to baby boomers and people aged 74 and over. And this likely reflects that younger generations rely on social media platforms to access their news and information more than older Australians. We also found a strong connection with trust in news. People who don't trust news were less supportive of political advertising on any platform. And those who do trust news were more supportive. So this possibly reflects that those who trust news also trust journalism's ability to hold politicians and political parties to account. As a result, trusters have lower concern about the possible persuasive impact of political advertising on them as voters. Higher educated participants were also more supportive than those with low levels of education, which might reflect greater confidence in their own levels of political and media literacy. Interestingly, right-wing news consumers were more supportive of political advertising across platforms than left-wing. We also asked participants how the tech platforms should deal with inaccurate or misleading political advertising. They were given two options. Should the tech companies block the ad? Should the tech company allow the ads because it's not their job to determine what is true or false? Or should the tech companies block the ad because they are responsible for the accuracy of the information on the platform? So they were the two options that participants were given. More than half, 58%, said it was up to the tech platforms to block political ads that could be false. And 1/4 said the ads should be allowed because determining truth is not the role of the tech companies. Almost 1/5 said that they didn't know. So that's 18% of people didn't have a view on it. Across all generations, people said the onus was on the tech platforms to block false political ads. There was also a big difference in response to this question based on political orientation. 69% of left-wing participants supported the option of tech companies blocking misleading political ads on their platforms, compared to 54% of right-wing. This possibly reflects a successful Conservative digital advertising campaign in the 2019 federal election, given that this survey was taken in 2020, early 2020. In light of the ongoing debate about the need for truth in political advertising laws, these results are interesting. Firstly, while the public might want the platforms to adjudicate the accuracy of political advertising content, the platforms are reluctant to take on that role. The voluntary Australian Code of Practice on Disinformation and Misinformation actively excludes this type of content from its remit. Secondly, it feeds into research by the Australia Institute and others that reflect a level of public support for laws that help limit political lying during elections. And in a climate where 61% of Australians expect government leaders will purposefully mislead them by saying things they know are false or gross exaggerations, according to the 2022 Edelman Trust Barometer, our survey results add weight to arguments for action that encourage politicians to stick within the guardrails of truth. Thanks.
So that's our opening statement, but we're happy to take questions and, where necessary, take questions on notice.
Excellent, thank you. I'll just clarify first, the data you're referring to, that's all within this report we've been given? No?
No, so all of the data that I was referring to is in this report, but the data Caroline was referring to is in the 2020 report.
And you can get all of these online, but I didn't have enough copies of this.
Put it on the record.
Yeah, sorry to bring.
No, that's fine.
They're all online.
Okay, thank you. I suppose I'll start with a broad point of discussion. Given that context you've just given us, given one of the reference points for this committee is to look at the potential for truth in political advertising laws. What's your view on whether we need them and how they should operate?
Do you want to start with that?
Sure. I think it would be a good idea. They exist in South Australia. They've been introduced in the ACT. We haven't actually seen them in action yet in the ACT. But it's not going to rule out all forms of untruth, but I think it does send a strong signal, and it does put up some guardrails around, the extent to which people can lie. And I think it could limit some of the more extreme forms of lying. One that I theorised with a colleague called, particularly strategic lying, which, lying has become, a very, disturbing and advanced spin technique. And it could help bring that back a little bit. So I would be very strongly in favour of us introducing that federally. As to how that would work. Well, look, we've got the model in South Australia. We've now got the ACT model, which is, loosely based on the South Australian one. I think, they're the ones we go with. I haven't given that side of it a huge amount of thought, but, from the reports and the research that I've read, okay, sure, it's not going to stop all gilding of the lily. That's part of political rhetoric. That's part, of the process. I totally appreciate that. I was once a media advisor for a politician. I understand the need for that. But I do think there's a strong need to rein it in.
I might just add that the other side to that is that we need really active media and news literacy programs. Nationally coordinated, so that it's not just about what's coming from the politicians, but it's improving the understanding of the community about how that information ecology works. Our research has shown that people have a very poor understanding of these changes that are going on in the way that they get information. And so I think that if you were to introduce those sorts of laws, it needs to be done with that audience in mind, with the community in mind, and it needs to be a coordinated approach.
Do you have a view on some of the current efforts in that space? For instance, the AEC's Stop and Check campaign?
Yep.
Look, I'm aware of it, of course, and that was a good thing during the campaign. But of course, they're limited. Their concern is about, untruths about the processes, the electoral processes themselves, not about claims, factual claims. Yeah.
Yeah, I mean, I think that's excellent. I think there are lots of other organisations that are sort of, really active in this space. The police are one of the organisations that come to mind. But I think what we're aware of is a broader public information campaign, or a broader education campaign to help people to understand, just what's going on and what they can do. People are mildly aware of the things that they can do to combat misinformation individually online. They're aware that you can take down posts, but they rarely see it happen. And so, I think there's a lot more that we can do that I think moves beyond individual piecemeal sort of campaigns and programs.
Are you suggesting there's a broader role for government there to be involved in
Would you like
running
to talk
a campaign
about
or something in that space?
Actually, in previous, I think, may have been the 2019 inquiry into the 2019 election. But we have done, we did a large body of work for the Department of Communication under the previous government, and looking at recommendations for media literacy campaigns, and we did recommend to them a national network for media literacy, and it was in response to the ACCC inquiry, and the need for media literacy there. And in fact, the government's response to that was that they did support the creation of a networked national media literacy campaign. That hasn't gone anywhere, but yes, we are strongly in favour of that and have done quite a lot of research into what that model might look like. And there is an existing network. We build on an existing network. It's called AMLA, the Australian Media Literacy Association, and it's involved with key institutions, the Museum of Australian Democracy, the Libraries Association, the ABC, a lot of the key information institutions would be part of the leaders of this network. Anyway, there's quite a detailed model for it out there, and it would be terrific to see that rolled out, a national program which took a coordinated approach. There's a lot of individual bits of media literacy education out there, and everyone's had to go out on their own because there wasn't a national effort. So, for instance, in the Netherlands, which this model is roughly based on, they went from the ground up and started with a national approach, and so they've got it's very coordinated, and all of those knowledge institutions, schools, etc., they're all linked in to provide quite a comprehensive set of media literacy education. That hasn't happened here, and so instead we've got all these spot fires, little individual efforts, all of which are very good, but they're not coordinated, and everyone's reinventing the wheel. And it would be great to have a more coordinated national approach to that. So I'm happy to dig out our report if you're interested.
Okay, thank you. And I suppose it also ties in with what we've heard from submitters earlier today, particularly in the space of misinformation and disinformation, around transparency in the space. What's your view on where things are up to and how transparent particularly social platforms are when it comes to misinformation and disinformation, and what we might need to look at in that space?
I'll start. Well, we have done research commissioned by the ACMA around, in the context of COVID-19 and people's exposure to misinformation. I suppose the first thing I would say is that when people talk about misinformation, they tend not to be thinking about, say, the extreme forms of disinformation like foreign interference. They actually are really concerned about bias. And I think, as the statistics we showed earlier, Australians are pretty assertive in their, in the way they like their news and information presented to them. So that would be the first thing I would say, is that there's a lot of muddiness around people's understanding of mis and disinformation. So if you think about, so people told us that they think it's not only the platforms' responsibility. They absolutely think the platforms have a responsibility, but they also think that government and individuals themselves have a sort of a three-way responsibility for dealing with misinformation. So, do you want to talk a little bit about?
So, I mean, with the new code, Digi, the code, it's voluntary, which, isn't ideal. It would be great if it perhaps it was mandatory.
I'll just stop you there, actually, because we heard from Digi that while they didn't have a particular view on whether it's voluntary or mandatory, that there are advantages in a voluntary code because it allows for a level of flexibility and for platforms to go beyond or adapt to their particular circumstance that maybe a mandatory code doesn't allow for. So I'll put that to you for you to respond to.
I only meant mandatory in the sense that all of the platforms need to observe it. Whether or not there's flexibility within the code, and then that's another issue. But I think the fact that it's an opt-in, whether or not they want to be part of the code and adhere to it, I think that would be good to remove that option. They do, of course, put out these transparency reports, and that's very useful. I guess we only know what they tell us, so we are very much relying on, and I'm not saying for a moment that they're not telling us the truth, but there's it's just an overall lack of transparency, I guess, and that we are very much dependent on the data that they supply, and it's very hard for us to verify that externally.
Okay, Senator Goodell.
Thanks for your report. Had a brief flick through, very brief flick through. Stuff saying with AMLA and communication being a two-way street, that we can fix what people say, but how people hear it is important.
Yeah.
Looking at the stats, like we're at, I think we were 17 or we're above average in the world for paid news consumption. And the next 5 or 6 better than us are at 18, 19, very close. But then you've got Norway and Sweden. Is there a cultural bias in what they do? Have they done stuff like the AMLA stuff you're talking about? Why are they double or triple the rest of the world?
Good question. There's so many factors, but we presented the statistic that in Sweden, I think it was 79% of people
Twice a day, yeah.
Consume the news. So it's again, I think it comes back to this media literacy and political literacy. It's a trust in government, and it's an understanding that news is a really important part of that. So I think yes, there are absolutely cultural differences. In the way that people in some countries, consume their news.
Yeah, look, it is really interesting, and it's a good. I mean, it is a good question about whether or not they've got sort of, a well-established media literacy education system there. Thinking back to the report that we did, it's a couple of years ago now, we did do an international scan, and certainly the programs, there were well-developed programs in that part of the world, so that may well have something to do with it. I mean, I hazard to even say, that even climate may well have something to do with it. Yep. I mean, we are, we tend to be a warm climate, and we spend a lot of time outside. We do other things, but in long winters, people read. So look, there's bound to be a range of factors. We have tried to look. It's not just as simple, I don't think, as just levels of education, etc. We have done international comparative measurements on things like trust in news. Why is trust higher here than in there? And it's always quite a messy picture. So I couldn't give you a straight answer about that. I think it's just several factors.
You've got lots of age demographics, lots of breakdown on political beliefs. Is there a subset that's not published about regional breakdown? I mean, that. Is there a regional, we've got our country papers, we've got our local papers, that sort of stuff?
About political orientation of audiences?
Oh, no, just news consumption generally.
Oh, yes.
Oh, okay. So, the main thing is that overwhelmingly all Australians want local news. So that's one of the findings. More than they want international political or sport, they want news about their local communities. And we have presented to the inquiry into newspapers at the end of last year, I think it was, or the beginning of this year. And so we have provided quite detailed information previously about regional news audiences. So, yes, more likely to use a newspaper is one of the things that comes to mind. Caroline, have you got?
Okay, I know. We, unfortunately, this year, but I might refer.
I haven't been able to read it yet.
No. This is the thing. Each year, because it's such a vast data set,
we didn't.
We hone in on different issues.
I'll show you this. This is from 2021.
All
it's
right.
really handy. We didn't do it this year, actually, because the report was just getting too big. But we have a thing called a regional snapshot. Okay. And we normally do this every year. And it does show considerable differences. So...
I'll go and look at that. That's safe.
Greater consumption of traditional media, so TV and newspapers still slightly higher in those areas. But also people starting to use social media
more as a main source in some areas as well to make up for the lack of
Diversity.
for closures. And we've done other research looking specifically at the impacts of closures, etc., on people's news consumption, their sense of belonging to their communities. We do quite a lot of work on regional media, so we could take anything on notice if you wanted anything specifically.
Can I just interrupt here
Yeah.
and just ask it? Is there a greater sense of trust in those areas?
Certainly in local news, people trust local news much more than they do news in general, yes. And people do feel very, certainly recognise the role of the local newspaper in their community.
You might
very
want
much.
to take a look at the heartbeat of Australia survey that we conducted earlier this year for the Australian Community Media, ACM, who, as you know, have dozens of masthead.
Most of Fairfax Regional, didn't
That's right, in regional, and particularly regional newspapers.
So you published that, they published that?
We conducted the research for them, and they publicised it very widely. What's it called? Pulse of the Nation. Our colleague, Professor Sora Park, is the lead author on.
So, sorry, can I just clarify so I can go look for it? Is it called Heartbeat of Australia or is it called Pulse of the Nation?
We'll have to
Yes, that would be
double-check
lovely.
Sorry,
If you could come back to
we
us,
take
that'd
that
be
on
great.
notice and get back to you, and we can send you information about that. Just looking at trust, overall people in regional areas do have a higher level of trust in media than people
Why?
in cities.
$1 million question.
Yeah, the $1 million question. Well, particularly if they're talking about their local media, is because it's much more relevant to them.
Yeah.
It affects them.
Yeah.
They often know the journalists, they have a connection with it, the stories that are told are about their lives. So much of the news media that we read in metropolitan areas have nothing to do with anybody. Often
We know generally from the report that people trust my news more than they trust news in general. So we tend to trust the news that we consume.
Yeah, but absolutely, all of our research shows, and traditional research into regional news shows that there is a loyalty, a sense of a belonging, yes, a sense of trust, because these people come from the community, they reflect the community, and they talk about issues that are relevant to people in the community. On the whole, the wider media diet is of issues that are, national scale. They're not necessarily directed at people's individual lives, and it's a problem. Its relevance is a real problem. It's one of their complaints about the media is that it doesn't reflect them.
And my last question is, there's lots of content around trust and different stuff when we're talking about misinformation. The one thing, is there anyone that does reports on content bias? So where I'm particularly concerned is an issue that is not in the general mainstream, is not there. I own a media outlet. I'm concerned with the native sea urchins encroachment on the kelp forest of Tasmania. So every second story is about that. Is there anyone that does research in content bias to drive opinion?
Well, we know this. Well, all of the studies, we do a lot of research into trust, and our research and international research. There's a great report, you'd love it. It's called Bias, Bullshit and Lies, and it was produced by the Reuters Institute.
You had me at all.
For the study of journalism at Oxford University, who we collaborate with closely, and it was a deep dive into trust, and that's exactly what people say. It's the main driver of low trust in news is perceptions of bias and partisan agendas.
Yep. So not just what you say, is what you're talking about sometimes.
Well, absolutely.
I mean,
yeah.
that's my research background is in news framing.
Yep.
So the way that a journalist approaches a story, the sources they use, the angle that they use, all of those things, they might be providing a fair and balanced report, but it will still be framed in a particular way.
And there's no benchmarking against public opinion to different media outlets doing that?
Well, look, I guess, we do, confirmation bias is
Yep.
a very real thing,
Yep.
and we tend to be attracted to news that reflects our worldview. Some people will read a diverse range that challenges their views. That's a minority of people, but on the whole, we tend to be attracted to the news that reflects our worldview. And so when we look at our, say, political orientation of our audiences, we ask people how do they identify across the political spectrum from left to right, and then we look at the brands that they use. It would reflect that people are turning towards the brands that reflect their political leaning. But, bias is also very much in the eye of the beholder. There's some
very, seminal kind of research into bias, which does show that it's, I'm just trying to the Vallon study, and I can't think of the name of the study. But it shows, they showed people the very same material about what was happening. I think it was in Lebanon, the war in Beirut or somewhere, and partisans on both sides, and both sides thought that the coverage was biased against them. So, it's...
That's perception bias as against content bias, isn't it, really? There's a difference.
Yeah, but yes, there's both. There's bias on so many levels. You can have editorially driven bias from the top, from the owner down. You can have individual bias from a reporter and their agendas. Every single choice you make in journalism is a selective process. The 10-second grab you choose. Why did you choose it? There's every single selection that you make to construct a version of reality is going to inject a level of bias, and that's the nature of journalism. Yeah.
I've gone over my time. Sorry, mate.
Very interesting discussion, particularly for a former journalist. Senator Waters, did you have some questions?
I do. Thanks, Chair, and I've enjoyed the discussion as well, and I look forward to devouring that report that you've tabled with us this morning. Thank you for that. I've received the e-copy, but I obviously haven't had a chance to read it yet. You've touched on a lot of the issues that I wanted to ask about, but can you expand, please? We talked about news literacy strategies, and you said that you've done a little bit of work on developing those with the previous government. Can you tell me a bit more about any news literacy strategies that might have been implemented since the last election, and what more you think should be done, and by whom, to increase people's news literacy generally?
I'm not aware of any news literacy strategies that have been implemented federally. Certainly, I don't know how much we're allowed to say. I mean, there were times where we thought that there was going to be an announcement about the work that we'd done, and we would be advised, and then they'd say, oh, no, it's not going to happen. And so we had several backwards and forwards about that. So I don't know what happened in the end, whether I'm allowed to say that or not, but that's the truth. So,
there was
a lot of goodwill
of
with the people we were working with, but there was no announcement from the government in the end about that. So I don't know what happened to it, where it got up to. So I'm not aware of anything since then.
I mean, if you're looking for examples of the types of education that's around news literacy or media literacy or information literacy, all of these, they're all have slightly different purposes. An example is the work that our research centre is doing with ALIA, the Australian Libraries and Information Association, where we are providing an online training course for librarians. And it's had a very enthusiastic take-up. So librarians are the types of people in the community who are out there, in there. It could be at a school library, and we've also done work with school teachers, but it could be in a school library or it could be in a community library. They're the ones that are faced with people who need to understand the information that they are exposed to, the individual, they're on the coalface. So that's where the activity's happening, and in other organisations, like you said. But to our knowledge, there's no, there hasn't been a national literacy strategy.
Okay, well, I don't want to put you on the spot, but I am interested in the parameters of the work that you had expected / hoped to be announced in the last term. Is there anything more you can say without getting anybody into trouble, just in terms of or perhaps I can phrase it as, how would you propose that the federal government best show some leadership in this area? What elements do you think we should be presiding over and putting in place?
Good point. Well, it has to be research and evidence-based. So I think there's probably more research that needs to be done in this space. We have conducted research about misinformation with the Australian Communication and Media Authority. We have done small projects on misinformation, and obviously we have our digital news report, which does give us lots of insights, but I think there is far more to be done. And then I think, all the players in the room, all the players need to get into the room. And as I say, there's a lot of different people with an interest here. There's the platforms, there's the traditional news media, there's educators, there's government, obviously, and then there's a whole range of community sector.
And just to elaborate on bringing everyone into the room, and that's exactly the plan that we put forward. So I just don't have it with me. I'm so sorry, and I'm really digging back into my mind now. I'm thinking, gosh, it's 3 years ago and a lot's happened. But it was literally a map of, who should be in the room, a diagram of what this network should look like and who should coordinate it and the funding that's required. And it was quite a detailed proposal, actually. I can see the diagram in my head. I just can't recite it all to you. But I can furnish you with a copy of that report if that's what you'd like.
Look, I think that would be fabulous if you feel comfortable doing that. I think the committee would very much benefit from sort of understanding the proposed scope of how to tackle this issue. Obviously, would have benefits in the political space, but would generally have benefits everywhere. So thank you. We'll gratefully receive that if I can say that on behalf of the chair. Thank you.
Okay.
Can I just build on that a bit? The AEC had quite an active Twitter presence in the most recent election. They're very strong on calling out mis and disinformation. They had a disinformation register. Do you have a view on whether that was a successful intervention by them? And any comments about whether they should go further?
We don't have we haven't done any evaluation of that. I would, from what we know, I would think that it's an excellent initiative, and that yes, of course, it should be that sort of thing should be supported. Caroline, have you got any more?
It's a good question. I'm aware of the register. I haven't. I personally haven't been to look at it, and I'm not aware of any evaluations that have been done. Just in trying to keep up to date with things, I haven't come across anything. So I'm sorry, I don't have a view.
No, that's fine. Thank you. And just one last question: has any analysis been done on whether there was a growth in either disinformation or foreign interference in the last election? We've spoken with some other agencies about this, so if this isn't in your remit, that's fine. But have you done any analysis on the growth or otherwise of disinformation or foreign interference?
No, not in the election context, but we did do a study during COVID, and one of the questions we asked was about misinformation about COVID-19 and also just misinformation generally, and people were much more concerned about misinformation coming from our own national governments than from governments in other countries. So there was much more concern about local misinformation than international. But that's just an aside. But no, as far as the election specifically, no.
All right, well, thank you very much for your work. And as I say, I look forward to reading your digest. And thanks again for your time today. Thank you, Chair.
Okay, thanks.
Thank you. A couple of questions really about what data you do and don't have. You made reference to the South Australian legislation, proud South Australian. We've been working under that for some years now. Do you have any way, and when I was thinking this through, I was thinking this is hard, any way of unpacking if there's a different perspective in, South Australia, because that's already regulated there, so is there a different perspective in South Australia that there might be in other states where there is no regulation? Or is that very hard to unpack because then you've got the federal scheme over the top, which obviously is different again?
Look, it's, you'd have to see it through the eyes of a politician. And as a media advisor, I guess, if I put on my old hat, I think, wow, there are no rules here. It's pretty tempting. I think that, you'd almost have to ask that yourself as a politician, if from South Australia, if you think about if you were campaigning in your own state and
and those laws applying to you, and then or campaigning federally, does that change the way you look at it? I would think that it would, but I'm not in your shoes. Well, I think it's certainly, for a politician, but for your average punter on the street, absorbing information in whatever news channel, because there's potentially, you would say, in a South Australian election context, you would see less of that because it is regulated. We've heard quite a bit from other people about how it's sort of influenced culture.
Yeah, so theoretically, yes, I think it would have some chilling effect, might be too strong a word, but, you know, a sort of a cultural impact on the way people just talk about the issues.
Yeah, I think so. I mean, the public clearly want some kind of regulation. They really want it. They don't want politicians lying to them. And they, you know, ultimately, if you didn't need rules to do that, then that'd be great. But it seems like we do. So, I mean, the public seems to want it. And I think it would increase people's faith and trust in the system. And trust in politics is low. So anything you can do to increase it would be a good thing.
Cool. And just one last question, because I know we're out of time, but I'm very much looking forward to reading your material. With the blackout rules, we've had some conversations. Do you think they still retain, that it's still relevant? And
It's a really interesting question.
if so, should everyone be captured by it?
Shall I have a go?
Yeah, I think have a go.
Yeah, I mean, it's not an area that we've done any research on, but so it's peripheral, so if you want an opinion. But yes, I think that, well, you go one way or the other. Yes, include all platforms would be my view. That would be my preferred position. Or you scrap it, you know, because it's crazy it only applying to broadcast media.
We could probably make a more general statement from the sorts of research that we do, in that politics needs to, you know, get into step with the changing media environment. You know, platforms are, you know, huge part of it, dominant part of it now, and so having rules just for a newspaper or a television station is not. It's just not the full picture. It's not. Yeah. So that's probably where more generally we would be wanting people to understand how important the online environment is.
And I would also just like to say that if it's decided, okay, to get rid of them because they're you know, redundant or whatever. And so that it's open slather. I think open slather is also really dangerous. So I think that if it did go across, if you take away the blackout rule, then I think, though, that it would be really good to still see some kind of, again, guardrails around how much advertising is permitted, you know, in those last days, or just, you know, instead of this bombardment and the micro-targeting and the splintering of information to different people. I think that is an issue that we need to about quantity of advertising, particularly on social media. I think that is another issue. So there's the blackout rules. Okay, are they still relevant? But let's look at the quantum of advertising and how it's being delivered, because there are real issues around, you know, whether a government even has a mandate amongst certain voters because they've received a completely different election campaign to someone else, you know. So I think there's much bigger issues actually here to think about other than the blackout, and yeah, the fracturing of the material that people are receiving, I think is actually, you know, it's quite concerning. So I think we need a much bigger discussion about advertising in general.
Thank you.
All right. Well, thank you for your attendance here today. If the committee has further questions, they'll be put to you in writing, and you'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to transcription errors. Thank you.
Thank you very much.
Feel free to do it, and they're online. Okay. Right, I now call on representatives from Free TV to give evidence. So the Hansard record, would you please state your full names and the capacity in which you appear before the committee?
Good afternoon yet? No, morning. Good morning, it's Bridget Fair. I'm the CEO of Free TV Australia.
And my name's Natasha Eves. I'm Regulatory Affairs Manager at Free TV Australia.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, and thank you for the opportunity to appear at today's hearing. Free TV Australia is the peak industry body for Australia's commercial television broadcasters. Our members bring Australian stories to Australian audiences, providing news, information and entertainment. And we're proud to be a trusted source of news and information. Recently, some independent research from JWS found that commercial broadcasters were the most useful source of news and information during the election campaign. Political parties across commercial television use it in order to connect with audiences, as our services reach almost 100% of the Australian population. However, the current election blackout regulations are no longer appropriate for a multi-platform environment. The advertising blackout period, as the committee is probably aware, prohibits advertising from midnight on the Wednesday prior to an election until polling closes. However, these rules apply only to commercial television and radio services. They do not apply to newspapers, out-of-home advertising or any form of digital media, including streaming services, social media or other online advertising. These regulations unfairly disadvantage commercial broadcasters, as has been recognised by the ACCC, which described them as a serious imbalance, and by this committee, which recommended the repeal of these rules in its 2020 report. This inconsistent regulation is not only commercially disadvantageous for our members, but also creates confusion for audiences who are not aware of the disparate rules and don't distinguish necessarily between digital and terrestrial television viewing. It's clear that the blackout rules are no longer serving any purpose. The rise of pre-poll voting sees over 30% of voters casting their vote before the election blackout even commences. It makes little sense to impose a blackout after millions of Australians have already made their choice. We strongly recommend that previous recommendations from this committee be acted upon and that the election blackout rules are removed from the Broadcasting Services Act. We'd also like to comment on the first term of reference to this inquiry, the proposed introduction of truth in political advertising laws. Free TV members are committed to meeting the very stringent requirements which already exist for advertisements placed on television. Should laws such as this be introduced, the responsibility for the content of these advertisements must remain with the authorising body. The compliance burden must not fall on broadcasters to determine whether an advertisement is likely to breach these laws. It would not be appropriate for broadcasters to make assessment of political truth, nor are they equipped to do so. We'd be pleased to discuss these issues further with the committee and welcome your questions. Thank you.
Thank you. I might start where you finished on truth in political advertising laws. So you're saying the entirety of responsibility in this space should rest on political actors and none on the platforms or broadcasters who take these advertisements?
Yes, we are saying that.
And why do you think that's the case? We could put an argument that broadcasters in a public conversation and a public information space have responsibilities themselves in terms of what they put on their platform and have responsibilities to comply with the law in terms of what's on that platform.
Yes, of course, we do have responsibilities to comply with the law, and in fact, we do comply with those laws each and every day in relation to both our content and in relation to advertising. But in relation to political advertising, the claims that are made in such advertising are very complex. would require a huge amount of effort in terms of interrogating whether, something was correct under forward estimates or other matters, and would be a serious imposition and compliance burden on broadcasters.
Oh, just in addition to that, if I may, Senator, a question whether it's appropriate for a commercial or industry body to be making decisions of that type and assessing advertisements in that way, whether that's an appropriate role for a commercial and industry body to take, which I don't think it is.
Do you take that role under any of your other current regulatory requirements at the moment?
We have a role in relation to the Australian competition and consumer law in relation to factual claims, but we're certainly not interposing ourselves in relation to matters of opinion or emphasis, and that would be a very different matter. And even in relation to factual claims would require and in fact impede much political communication by political parties.
So can you explain for the benefit of the committee what your current role in that ACCC factual claim, I presume this is the misleading and deceptive laws, comes in?
Yes, so in fact that primarily rests with the advertiser, but we do review laws to assist advertisers with that imposition of rules and require them to provide substantiation.
And is that a requirement when an advertiser provides an advertisement, or is it that someone looks at it and says, I think this might butt up against the laws, and you go back to the advertiser?
Free TV has a service which is known as Clear Ads. Advertisers pay to use that service, and that service reviews and classifies advertisements in relation to a range of laws and industry codes. And so matters which may be relevant under the Australian consumer law are brought to the attention of the advertiser, and further information is requested.
Thank you. Senator Scattell.
No, similar point. I mean, going back some history, we had advertised a ballet school, and it was lovely princesses in pink. But we got a request. We had to have the mum who was making claims about how it was a great ballet school. She had to fill out stat decks and everything for the ad to appear on TV. Why is that for a consumer process a suitable process, but not for a political process?
Well, under our constitution, there is a differentiation between claims that are made in trade or commerce and freedom of political communication. And so there's been it's a matter of law that there's a differentiation between those two types of communication.
I understand, but if we were to minimise that difference, that process already exists for commercial processes. Why can't the same process exist under political processes?
Well, that's really a matter for the Parliament. What we're saying is it's not the role of broadcasters or industry bodies to step in between a political party and the Australian public in determining the not just relevance but ability of a party to make certain claims. That responsibility should rest with political parties.
And even though it lies with the Parliament, do you suggest a method or a process on who would be best to deal with that? If the Parliament was to legislate a body, who would you suggest?
We haven't turned our mind to that.
Okay. On the blackout media laws, is your proposed, when you say removing 2/7/1H of the Broadcasting Services Act, that it be removed entirely, or just a levelling of the playing field across different media types?
Our proposal is that it's removed entirely, and that's because political communication on online and social media platforms is not limited to advertising. And in fact, by prohibiting advertising on legitimate platforms such as television and radio, you're actually denying the Australian public legitimate sources of information from people who are prepared to put their name to their claims rather than malicious actors who might be, promoting information via social media and other channels.
But given your own testimony says 62% of Australians find News TV the most trusted source of news and stuff, doesn't the fact that it merely appears on TV add greater credibility than social media in those last few hours or days of a campaign?
Well, and that's indeed my point. I mean, in the last days of a campaign, you may find malicious actors promoting various pieces of information via social media and other channels, and it is you're denying the Australian public the ability to receive trusted sources of information via advertising on TV and radio that may counteract those claims.
Okay, thank you. That's all, Madam Chair.
Thank you. Senator Waters, did you have some questions?
Yes, thanks very much, Chair. Thanks for joining us today, Free TV. Just to continue on that line of questioning, I hear you that you don't think it's your role to assess the truth or otherwise of political ads, but and the Chair sort of progressed this with you. At the minute, you've got liability as publishers for defamation. So I'm just struggling to understand the distinction between what changes you'd need in your practice to deal with defamation, which you've already got to deal with, versus some kind of, publisher liability should there be truth in advertising rules implemented by Parliament. Can you just explain for me your reasoning?
Well, defamation is a very confined matter of consideration, and actually, in reality, very rarely arises in the course of political campaigns. But the volume and number of claims that would come through in relation to political advertising during an election campaign would impose a very significant compliance burden on broadcasters if they were required to review each and every one prior to broadcast. And also there would be a question as to whether we were standing and preventing some people from making claims over and above other people. And we have had some experience of this in the past where, very much earlier in this century, there was a mistaken view that during one election campaign that this in fact needed to take place, and in fact it became a serious impediment to people getting their ads on television. And broadcasters were simply not equipped to deal with, the complexity of the claims that needed to be reviewed.
Okay, would it make it more workable from your practical perspective if the people placing the ads were required to certify that the ad would not be in breach of truth in advertising laws? Would that make any difference to your view?
Well, if that was the assurance that was given by the advertiser, and having received that assurance the broadcaster was not primarily liable, then that of course would be something that we were comfortable with.
Okay, thank you. Would you support the establishment of an independent leaders debate commission to determine the date, format, broadcast and participants in leaders debates during an election campaign?
We've been on record of supporting some form of arrangement to determine debates, and I think a proposal was put to various members of the media in the lead up to the last election. Whether it's a formal commission or what form it took, we hadn't formed a fixed view. What we had said was that free TV broadcasters, who are, one of the main ways that people receive their information, should be part of any such decision-making process and should be appropriately recognised.
Okay, thank you. And just one final question from me. Dr. Belinda Edwards has recommended to this inquiry that there should be a stronger media code regulating free airtime given to minor parties and independents to level the playing field in election campaigns. Does Free TV have any policies to balance the amount of time given to various political players? And are you aware of any policies that any particular stations have about ensuring that there's a diversity of views, panel shows or interviews or the like?
We, I think, have to provide reasonable opportunity to anyone who wishes to advertise on our platform. And that's as far as our rules go. We obviously have confined amounts of inventory. We're limited to certain amounts of minutes per hour, depending on the time of day. And so it's a matter for, we're a commercial business. It's a matter for people to buy our commercial services, and we make those opportunities available to anyone who wishes to do so.
Okay, so just for clarity, you don't have any rules, internal or otherwise, that require you to ensure there's some kind of parity. It's just whoever can afford the airtime gets the time.
We offer a reasonable opportunity to anybody who wants to purchase the airtime on the same basis. So there's equality in that sense.
All right, thanks very much. Thanks, Chair.
Thank you. Senator Grogan, did you have some questions?
Most of my questions have been covered, but I will go back to the idea of who should regulate any truth in political advertising. Now, you said you haven't really turned your mind to it, but there is a debate about whether it should be allocated to an existing organisation or whether, if anything was to be done in this space, that it be an entirely new construct. And then there's the option that some people have put forward, which is the Australian Electoral Commission. Do you have a view at all on which of those avenues you could see as being the most valuable, in your opinion?
Look, I'm sorry, we haven't considered what should happen. Our views have really been confined to not wishing to place ourselves in the political process as determining which ads should and should not go to air during an election campaign.
Okay, and your view about the blackouts is to just remove it?
Yes.
What if it was applied to all platforms? How would that impact, do you think?
Well, we live in a world where significant amounts of information and campaigns are run other than via advertising. And so simply applying rules to advertising would leave all the other types of misinformation campaigns, which everybody's very familiar with, unregulated, and prohibit legitimate advertisers from trying to counteract some of those campaigns via advertising. So in fact, some of the people who most need legitimate sources of information would be denied it.
What if it was applied to paid advertising, for example, all paid advertising?
Well, I think that would be very dangerous, because unpaid material where bad actors try to fan the flames of information campaigns not via paid advertising would be unable to be counteracted via paid advertising.
Okay, thank you.
All right, thank you for your attendance here today. If the committee has any further questions, they'll be put to you in writing. You'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to transcription errors. Thank you. I'll suspend.
Thank you, Chair.
Thank you. I'll suspend our hearing until 1:30. Right on time. Here we go. And I now call on representatives from the Australian Competition and Consumer Commission to give evidence. For the Hansard record, can you please state your full names and the capacity in which you appear before the committee?
Chair, my name is Scott Gregson. I'm the ACCC's Chief Executive Officer. And joining me today is Rami Gress. and I'm the Executive General Manager of Consumer and Fair Trading at the ACCC.
Great, thanks. Can we just get the volume turned up on these witnesses, please? Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we go to discussion.
Thank you, Chair. I won't provide an extensive statement, but perhaps just a short introduction that might frame the issues that could arise. Look, we understand a number of the issues the committee has considered in recent hearings and indeed in submissions has been the issue of truth in political advertising or debate. And these are really important issues. We see and understand them, but they're not matters that are currently within the remit of the ACCC. And just to give you the background to that, our legislation is rightly entrenched, in our view, in the realm of addressing conduct in trade or commerce. That has both a constitutional origin, but also clear, and perhaps more importantly, clear lines of alignment to our mission or mandate of both the legislation and the agency. We are very much here to address concerns about conduct in and functioning of markets, not really focused on political debate. There's a long line of court precedents that assist with determining the line between the two. We're happy to talk about those as questions arise. I think as we pick up the submissions and the areas of topics, as we have in the past, I think suggestions that the ACCC or our legislation might seek to deal with those issues would, with respect, have a significant impact on the clarity of our role and draw the independent champion of competition and consumer issues into political matters, which we think would impact our effectiveness. With that introduction, Chair, we're very pleased to assist the committee in any way we can and look forward to questions.
Thank you. Well, I will start where you just took us to. We did have and have had a submitter suggest that one of the cleanest ways of dealing with truth in political advertising would be to expand the current definition of deceptive and misleading as it is in consumer law to extend to electoral law. And they put to the committee that it's a well understood definition, under the law, and therefore makes it a useful and workable one for us to consider as we look at this issue of truth in political advertising. Would you like to comment on that?
I'll start and then see if Mr. Gress has some further advice, Chair. Absolutely right that over decades of precedent and effective enforcement by the ACCC and others, I should say, there is a very clear understanding about what misleading and deceptive conduct, false and misleading representations constitute. Though I should say that's very much in that context of what conduct we look at, which is in trade or commerce. It's about a commercial relationship very often between consumers and traders, or indeed between traders themselves. Applying those concepts to political debate, debate in the public arena, wouldn't have a complete ease of transition. And indeed would perhaps require quite different considerations. Beyond that, just going back to my earlier comment, Chair, we do see quite a difference in terms of roles, mandates, missions between regulating the marketplace and becoming involved in matters of political discussion, and think that it's not a good transition or role for an agency such as the ACCC. I'll just see if Mr. Gress has a comment.
Well, I'll need to say that, as you rightly point out, the law and the frameworks for misleading and deceptive conduct are well known, and they're also administered externally by our external lawyers and counsel, so the expertise does exist when it comes to at least the legal framework, which is able to be tapped into by other agencies if they're deemed more appropriate.
I just might ask you to unpick a bit more why you're saying it's a completely different arena. So there are laws in place that, if a corporation goes out with a claim in an ad that is untrue, there's a role for you and these laws. If there's a political party at the moment that goes out and says, well, vote for me and I'll make sure that every day it's sunny, there is no law that attracts that. But that statement perhaps is no different to a company that wants to advertise and says, I have a magical new machine that will make sure it's sunny every day. So can you draw out for me more why you think there's that distinction?
And I'll make a start, Chair. The engagement between customer and seller in a marketplace does have a lot greater definition, I think, in terms of what is being offered and what is being presented as being available for sale or purchase. It has a greater degree of clarity to it. When dealing not just with political advertising or statements, but also just public debate, which our legislation intentionally strays away from, you're often getting into battles of ideas, thoughts, opinions. And yes, they can arise in a commercial context, not to the same extent or with the same precision. We think the legislation appropriately differentiates and doesn't seek to, stifle what otherwise might be public debate on those issues of ideas, opinion, etc., or the political world. I think conflating the two would cause quite considerable challenges. I should have mentioned at the start as well, our regime is very much when the ACCC is not the arbiter of what is misleading or deceptive. We operate in the judicial system where we must take ultimately matters to court. I think there's a further consideration there whether that is a suitable process for dealing with some of the challenges that I think the committee has been grappling with as well. They're understandably quite extensive processes that we ultimately get to if we're taking matters through that process.
So I presume they're quite lengthy when you have to go to court?
Absolutely. Our cases will invariably take months, if not up to a longer period of years to investigate. And once they're in that court process, can take equally months through to quite common multiple years to get through a first hearing and possible appeal hearings.
And maybe I can add as well that, we filter tens, if not hundreds of thousands of referrals each year to essentially taking action against a relatively small number. And we have to assess the seriousness of the conduct, the impact on the economy, and also the ability to prove our case in court, ultimately how well the evidence stacks up. Concern in a more political framework would be where we make that assessment, and if we take on one complaint but not another party's complaint or another political perspective, it will obviously result in cause bias and the like, which when we're dealing with corporations is of little consequence, but in this realm would be quite concerning for an organisation that has to be apolitical.
Okay. Thank you. I might quickly ask as well about misinformation and disinformation and digital platforms. I know obviously you conducted your inquiry into digital platforms and we've been hearing today about the voluntary code that I think sort of arose down the track from that process. Do you have any views you'd like to share in that space with the committee based on the work you've done?
Probably not a lot more than you already have before you, Chair. You're quite right to point out that the relevance of our earlier digital platforms inquiry, which we think was groundbreaking in many ways. It addressed a broad range of issues that government directed us to look at. And perhaps went beyond some of the things that we would normally look at under our Competition and Consumer Act focus. As you note, one of those was really to identify the breadth of and concerns and harm associated with information, disinformation, particularly in relation to material on platforms, and we put forward a number of recommendations. So the majority of those recommendations, once made, while we've continued to show an interest, they have been for either government or on direction from government, other agencies or departments to progress. And I think the ones that you're referring to there have been picked up and being progressed by other agencies such as ACMA.
Okay, and final issue that may be relevant to you that we've also been dealing with today, which is the media blackout period, and whether this should be extended to other forms of media or scrapped entirely. Do you have a view around that from a competition point of view?
Well, we do in terms of the disparity and the impact that might have on competition. In our case in the digital platform inquiry was to point out that disparity, to suggest that it may want to be addressed, but we were sanguine or didn't express a view as to which way you might go in terms of introducing restrictions on platforms or removing it on traditional media. We would still have the same view and are watching that progress with interest.
Okay, thank you. Senator Goodell, do you have some questions?
I do, Madam Chair. So what we find in this committee is we have a number of people telling us that we should look at more in truth in advertising. We have even more agencies running away from that. It should be them that do it. So even without that process, let's just go through ACCC. We might learn something from the process you spoke at, because another quote was the expertise does exist. How many cases on misleading claims would you have ongoing at any one time?
So in relation to our consumer fair trading litigation profile, Mr. Gress might correct me, but historically we've averaged about 20 matters in litigation at any one time. Okay. Through the course of a year, we may undertake in-depth investigations of between 60 to 80 matters, depending on the complexity.
Okay, and what's the process for the ACCC to receive a case?
Yeah, we get leads and information through a number of sources. We do get reports from the public and we triage those. We have a further process of setting our priorities each year, which is based on input from a broad range of stakeholders. And through that process, we identify areas that we can be responsive to or proactively engage with. And we're also able to pick up matters that are public in their nature, either through media reports or other forums such as references in social media. So we have a broad range of matters and ways of getting matters, but we ultimately don't operate as a complaint handling agency. Yep. We very much seek to be a strategic enforcer to deliver greatest impact in the marketplace and deterrence.
Okay, so you said in that triaging, do you prioritise cases that may be time sensitive, and if so, how, or do you treat everything the same?
Sure. So one of the factors that we take into account, and this is in our public documents, is the extent, breadth and nature of harm that is being experienced, and where that might involve imminent or continuing harm, that would tick some further boxes in terms of the speed or manner in which we pursue it.
Okay, so that was extent, breadth and nature of harm. So that's good. And on those cases that you do go through to prosecution, is there a percentage you're successful on, or is there a unsuccessful or settlement or no action taken? Do you have those stats roughly?
I'll go to Mr. Gress, but we are successful in the majority of consumer cases we take.
That's to hand. I can confirm it is the majority that we're successful, and there's even in the case of successful matters, they might be jointly agreed and put to the court, or they might be completely contested. And occasionally we accept administrative outcomes that don't necessarily involve the court, so that happens as well. So there's a range of outcomes, but we can provide statistics of that.
Madam Chair, if we could get that on notice, that'd be great. And would you say the ACCC has extensive experience in dealing with truth as a concept in commercial matters?
To the extent that that's part of the framework for considering what's misleading, deceptive, or a false representation, that's fair to say.
So, should this government or otherwise this parliament choose to make, in the game of musical chairs, you are the last agency to get away from determining truth in political advertising, could you apply those same principles in political process?
No, I think as I mentioned in the introduction, I'm not sure there's a complete translation of those principles. There would certainly be some degree of shared lessons, but also a challenge in conflating the principles that might apply in a commercial context versus those that might apply in a public debate context.
And whilst I accept it is the job of the parliament ultimately to decide how this is done, and the easy answer is it is the job of the parliament, would you have any recommendations? Would this be another government body, or would there be a new body? Who would you see best placed to do this if it was to happen?
Yeah, I'm not sure we do have a position on that. I apologise that it's not helping you in those deliberations. And look, I might take the opportunity there to note, I think the ACCC has a pretty good track record of taking on new roles and responsibilities. Certainly not shirking public interest where we can. This is one, though, we do think is fairly fundamental in terms of our framing, and one that we would quite frankly sort of recommend against ACCC or our legislation being a vehicle.
Okay, that's all for the moment, ma'am.
Thank you. Senator Grogan, did you have some questions?
Yes, thank you. With your work on scams, do you have are there any political themes through there?
No, not really. Scammers are traditionally opportunistic in terms of approaching broad sets of consumers, but in particular vulnerable consumers. They operate on the basis of large volumes of approaches, taking a proportion of victims, moving quickly, morphing. While there can sometimes be a political backdrop to the scheme of the scam, it's not something that we think drives this or is a political issue per se.
Okay, thank you. And in terms of you had an interim report on online private messaging. Is that messaging just in terms of your consumer role, or is that across the board in terms of spend? Just a point of clarity, really. Was it all commercial, or was it broader than that?
Oh, no, that was commercial.
So,
the commercial nature of the platforms that are involved, that's right.
Okay, thank you. That's it.
Thank you. Very efficient. I think we have concluded questions. So thank you for your attendance here today. If the committee has further questions, they'll be put to you in writing, and you'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to transcription errors.
Thank you, Chair. We appreciate your time.
Thanks.
Yes.
Or can we see if they can you try and get them early? So,
yeah, we can. But we can just suspend it at the moment.
Yeah, I'll suspend the public hearing. Representatives from the Australian Broadcasting Corporation to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Good afternoon. I hope you can hear me. My name is Craig McMurtry and I'm the ABC's editorial director.
Thank you, Mr McMurtry. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Look, our submission speaks for itself. I'm very happy to move directly to questions and discussion if that assists the committee.
Excellent. Thank you. Senator Grogan.
Certainly. Thank you, Mr McMurtry. Do you want to maybe start by exploring with us the role you see the ABC taking in terms of trust in the media. As, you know, the Australian broadcaster, there's frequent debates about trust, faith, who is the who holds the kind of the truth genie. How do you see the ABC committing to that and holding that standard?
Thank you for the question. So, look, in broad, thinking about ways that we can all encourage greater electoral participation. We say in our submission, and the argument we're putting, is that the ABC is the best single mechanism to do that. We are the most trusted news provider. We are the destination. People come to us at election time. They come to us whenever there is a significant news event, particularly at election time. ABC News Digital was the #1 news provider. The television broadcast on election night was the leading television broadcast. 70% of Australians engaged with ABC coverage during the campaign. And we have extraordinary terrestrial broadcast reach, 98.6% on television, 99.6%, I believe, on radio. So our position is we are the most trusted, we are the best mechanism for, if we're talking, for example, about televised debates, we are the best mechanism for the leaders seeking the vote of Australians to reach out directly to those Australians and put their case.
So a couple of things I'd like to follow up on.
Sure.
Maybe we'll start with your recommendation for a debates commission. Do you feel that that's needed? Is that a little? It seems extreme in some ways to set up a commission for debates every 3 years. Do you, obviously it would sit in abeyance for a time. Do you want to just expand on the rationale for that?
Well, so in a mature democracy, I don't agree that it's an extreme move. It's interesting that late in the piece in the last political cycle, and to its credit, the coalition tried to get a debates commission idea up and communicated with the media and with the parties. In the end, that proposal was not successful. The core issue I would suggest is what's in the public interest. And right now, when it comes to organising live debates, the first proposition is voters would ordinarily expect to hear from leaders seeking their vote to become Prime Minister. There is no guarantee that there will be live televised debates. That's always quite an elaborate and mostly backroom negotiation, normally in the throes of a political campaign. And we are suggesting that if a debates commission was established, which we think is reasonable in a mature democracy like Australia, if it was established outside of the frenzied time leading up to a federal campaign or in the middle of a federal campaign, then that could reassure the Australian voters that they are going to hear from the leaders seeking their vote, that it's being dealt with in a fair and transparent way by an independent commission that would then engage with the major parties and with media representatives over the allocation of those debates.
So would you see that commission then being able to compel a party? Because I think one of the things there, as you say, it's normally a debate between the two parties behind the scenes sort of about what debates will occur. And I think your submission goes to the fact that at the last election, there were so many caveats placed on it that it never occurred. And is there a piece there where you think that the two major parties should be compelled? Or do you feel that maybe the ABC should have the obligation to run them? Because I think a lot of us do expect the ABC to run that debate in the lead up to the election. Should it just be that you're obligated, but then the various parties don't need to attend?
So there are a few things in that question. I suppose ultimately it is always up to the leader of a party to determine whether or not he or she is going to attend a debate. And there are examples. I mean, the recent example, a slightly divisive one, is in the United States, for example, over the debates commission there, where the Republicans, particularly the former the president, Donald Trump, wasn't happy. And in the end, one of the debates didn't proceed, I believe. So in terms of mandating, we would say that there ought to be a live televised debate on the ABC. We would say that the expectation would be that there would be a minimum of 3 live televised debates. And then it would be for the debate commission to determine the format, to allocate to, after consulting the respective media organisations, where it should sit. But yes, we would say that one of those organisations with a live televised debate ought to be the non-commercial public broadcaster for the reasons I've already articulated. And in terms of carrying debates hosted by others, that's an interesting one, and I think maybe also speaks to why we believe it's time to have a conversation about this. So at the leading up to the last election, there were conversations going on between us and other media organisations and the 2 major parties. The feedback we were consistently getting was that the ABC was under active consideration to host a live debate. So in that context, when other media are allocated debates, we have to make a decision about whether we're going to carry that debate. We have to balance that against our obligation to retain editorial control over what we publish. We're not party to those negotiations. We don't know what visual imagery is going to be used. We don't know what subjects are going to be canvassed. So in that situation, the commissioning editors took the not unreasonable proposition, I think, that took the view at least, that the right thing to do was to run an extensive post-debate special examining the key issues that arose in the debate, because in the lead-up, we were hopeful of securing our own televised debate. But of course, in the end, we didn't, because the final debate was allocated to the 7 network. And I make no criticism, by the way, of other media organisations pitching for debates and seeking to secure debates either. That's perfectly reasonable. What I'm saying is that the ABC is uniquely placed as the non-commercial national public broadcaster because of its extraordinary reach, and it should also have a televised leaders' debate.
Well, I think, as you rightly point out, you're not in the same category as the commercial providers. It is a very different approach, which would lead you to believe that a leaders' debate would be a reasonable thing. Is there any other way of achieving this other than a commission or amending the Broadcasting Act or something like that?
Well, so we're not being so prescriptive as to sort of say, look, this is the mechanism to do it, because I'm certainly not a legislator. I would note that the Parliamentary Proceedings Broadcasting Act requires us to carry already the proceedings of the House and the Senate. So there clearly are mechanisms to do it. So we are saying that if this committee and ultimately the Parliament doesn't agree with the idea of an independent debates commission, then we would like to see action to ensure that the ABC does carry a live televised debate. At the very least, we're looking for a recommendation from this committee to that effect.
Great. So that kind of takes me to another issue. In your submission, you talk about the complaints that you received and provide some statistics on that. With the editorial complaints, and you may not wish to answer this, do you feel that there's a theme through those of the difference between an accusation of bias and an opinion? Like, were there any themes throughout those complaints that you have any sort of more granular detail than what's in your submission?
So the scale of the complaints weren't particularly unusual. There was one interview with Senator Penny Wong on Afternoon Briefing that generated more complaints than others, some 200 complaints. There were no particular themes because it varies enormously depending on the campaign and the issues being prosecuted in the campaign. It is not unusual for bias claims to dominate in the election period because bias is very much in the eye of the beholder. But no, the short answer to your question is there were no particular patterns or themes that emerged other than just observing that there were a substantial number of complaints over that one afternoon briefing interview, which skewed the results somewhat. 119 in this past campaign, I think 119, there were 119 investigations carried out by the Independent Complaints Unit, Audience and Consumer Affairs. I think they found breaches in 7 cases, representing something like 6% of all the investigated matters, which of course is a fraction of the overall output.
And that one that you reference with Penny Wong, there was no substance found in those complaints.
No, they looked at it. No, so obviously some issues are more triggering than other issues. And this one was a conversation about the security of information relating to the AUKUS deal. And Audience and Consumer Affairs took a look at it and didn't find an issue.
Thank you. I think that's it. Thank you very much. Appreciate it.
Thank you, Senator Cadell.
Thank you, Chair. You mentioned in your opening statement, answer to a question about the previous model that the government put forward for a debates commission. Is that still fit for purpose, that model, as you saw it?
So the ABC was certainly prepared to keep talking about that as a model, but in the end, I think there was disagreement elsewhere. It wasn't a perfect model, I think, and you may well be way more familiar with it than I am, but I think, if I recall correctly, there was a proposal for the government to appoint the convener of the commission. There was some debate over the number of media representatives on that commission, but it is certainly true to say that we like the idea of at least a commission being discussed. Yep. We also think that it would have been better if the idea and proposal had been brought forward before it was. We felt at that point the environment was already pretty intense, pretty highly charged, and it was always going to be difficult to get broad agreement.
So get it done now when we're nice and calm.
In essence, yes.
Okay. In your review, you referred to the review by Mrs. Ridout and Oakes. I think it says, and I may be misquoting because I've written it poorly, no serious questions on all issues. What time period was that review done over? Was it the entire election period or was it a shorter area or?
No. So the way these external reviews work is we approach eminent Australians, in this case Heather Ridout and Laurie Oakes, who were good enough to give us their time and expertise. We consult with them over when they think an appropriate time to get a sample that is going to be a meaningful sample. As you would appreciate, depending on the length of the campaign, there are multiple ABC platforms, radio, TV and online. It simply isn't possible to measure everything. They select essentially and consult with us the appropriate time. This one was over 2 weeks, but they did make comment about some matters that fell outside that 2-week period.
Do you think it may be worth the taxpayer money to actually look at a longer, wider scope if for those things that fell outside, seeing the election is under such scrutiny?
So we produce a number of reviews. We do an election coverage review committee report, which is published. We commission iCensure to do a share of voice analysis, which is published. And we commission an external review, in this case by Laurie Oakes and Heather Ridout. I think that's a pretty good sample, a pretty good representative sample. And of course, it's always open to the ABC board to commission further reviews if they think it's necessary.
Okay. You just mentioned then the election coverage review committee that goes through. Who's the group that makes up that review committee?
So there are representatives from across the ABC. It's chaired traditionally by the person in my role.
All ABC staff?
Yes, it is ABC staff because its primary purpose is to track performance during the campaign, and we get the reports from iCensure, the share of voice reports, and then the final report of the Election Coverage Review Committee is presented to the board and then published.
Have you come up against potential conflicts of interest with, staff marking their colleagues' homework or anything like that? Have you come to a part where people have to excuse themselves, or is it all pretty much by the book?
Not at all. It's a pretty serious conversation. It's normally looking at the issues that are bubbling up in the campaign, how the share of voice is tracking to ensure that the parties are getting an opportunity on ABC platforms. It's quite a granular conversation, and it's dealt with. We do it on a week-by-week basis in the campaign to ensure that the ABC is tracking appropriately in its coverage.
Previous witnesses today have spoken a little bit about bias exists in everything. I think we're all in a political process. It's quite hard to be full and frank and fulsome in all necessary regards. When you're doing your review, is it possible to look at a sentiment analysis of your stories as well as just timings or stuff like that? Is there there's certainly software on social media and things like that can do a sentiment analysis story based on keywords and phrases. Do you do that as well?
We don't currently, because the processes that we're following now, we've followed for recent elections, and the board is satisfied with the settings we've got. However, we commission external reviews every year. We publish, on average, I would say, certainly in recent years, 6 to 8 external reviews, and we work with academics on different methodologies to sample sentiment and other things. So it's an area that we are constantly exploring.
And the last one is, we had some people this morning talking about how local news is the pinnacle. ABC is nice and trusted, but local news in local areas is the pinnacle. Anecdotally, and it is only anecdotally, so you can find me down here. Regional country towns, I'm a Nat, this is where we come from. The complaint that has come through to us is about content bias. It's that, it's not that the stories weren't balanced or they weren't, equal times or anything like that, but into areas that were not focusing on particular issues. There were, the journalists were choosing stories that weren't overly relevant, and that content analysis was there. Have you done a review of content analysis by issue over time during the election at all to see what stories were spoken about the most?
So the iCensure Share of Voice study does produce results that shows the subjects that dominated.
Yep.
And the voices that were heard most. And there's also some information on the sectors that were heard from.
Regionally, does it break it down?
I don't have the report in front of me, but it is published. You can look it up. The only thing I would say is, the only other thing I would say is we have such tremendous reach, and we have dozens and dozens of bureaus and radio stations dotted around the country. Our journalists and content makers live in those communities, and they are best placed to reflect to us the issues that matter most to their community, and they certainly do that.
Okay.
Thank you. Senator Waters.
I sent you a share of voice.
Thanks very much, Chair, and thanks, Mr. Magmotri, for your for the work you do for ABC and for your time today. I want to start off with the Debate Commission. This is something that the Greens have long supported, so I'm pleased to hear your advocacy and the specifics of what you've proposed so far. And I've heard the questions and the responses today. Can I ask whether or not your model includes who the participants should be? Because obviously we're from a smaller party, but we think we should be in on the leaders' debate, and particularly given that we now hold the balance of power in the Senate, you could argue that it's reasonable for parties that might be in the balance of power that could be in the leaders' debate. So can I ask whether or not in your model of the Debates Commission you would have the Commission determine whom is participating in those debates?
Look, that is certainly for the Debate Commission. But the only thing, and I do understand why you're asking the question, there were particular characteristics around this most recent election in terms of the performance of independents in particular that made it an unusual and interesting election result. I guess I'm obliged to say that our approach is firstly not to be so prescriptive as that. We are saying there should be televised leaders' debates, and that is one of the matters that would be for the Independent Debates Commission. But generally, I think the public perspective would be a desire to hear as much as possible from the individuals most likely to be the next Prime Minister. And in general, that would be the leader of the government and the leader of the official opposition. But in our model, as you say, we are not being that prescriptive, because ultimately that is a matter that should be for the Independent Debates Commission.
Okay, so that's within, you've said that you think that should be within their scope, even though you have a view that you think it should just be the two potential prime ministers. You're okay with the notion that the Debates Commission be the arbiter of who's the participant in that, in those debates?
We are saying that the Debates Commission should be charged with bringing live televised debates to voters to ensure that they are fully informed. They should hear from the leaders directly in a debate form. And we are saying that generally, because we do this with our allocations, I suppose, of free time under board policy during the campaign, we don't, as you know, we don't take paid political advertising, but the predisposition is generally that voters need to hear from the government of the day and the official opposition. That's not to exclude others, but in a debate context, that is the predisposition.
Okay, thank you. Well, just on that free airtime, does the ABC have, pardon my ignorance here, do you have your own internal policy in relation to that? Or are you just subject to the same overarching policy that SBS is, for example? And depending on your answer to that, were any changes made to that policy prior to the last election?
No, policy was well established and it was followed at the last election. The policy sits with the board. It's been that way. I mean, the ABC has made free time spots available on ABC platforms, I think, since the 1930s. And again, it's all around this notion of ensuring that we are doing everything we possibly can to encourage electoral participation and to present information to voters. So, in essence, what we say is you have to be a registered party, you have to be standing candidates in a majority of states and territories, you have to be getting 5% in established, credible, published polls, and obviously we take into account incumbency, the number of seats held when we are allocating free time spots. And the other thing that we do with free time spots, which is possibly helpful to the committee in relation to considerations around truth in political advertising, we do have quite strict rules around what can be in those free time spots. So we say that they shouldn't contain defamatory or personal attacks, misleading stylized images, unduly prominent slogans or jingles. Messages have to be about policy by the candidates. The content should perform a public service and be relevant and suitable. Use of stereotypes and discriminatory content encouraging prejudice isn't allowed. And in our experience, the parties observe those rules and are pretty responsible. We don't routinely fact check those spots, but if there was an egregious error, we could challenge it, and ultimately it's at its discretion.
Thank you, Mr. McMurtry. You did anticipate my next question, which was to ask whether or not you have a truth in advertising lens on the free airtime or just the defamation check. So appreciate that you've given us a detailed outline there of the approach you take. Dr. Belinda Edwards has recommended to us that there be a stronger media regulation of time given to minor parties and independents to level the playing field. Can you elaborate on any policies that the ABC has to balance the amount of time given to various political players?
So there isn't a set formula. If you look at the iCensure share of voice analysis, particularly for radio, I think that reflects pretty accurately where the electorate landed. It's a very complex picture for us because, of course, we have national platforms. We also have local platforms. So local radio stations dotted around the country will engage with candidates, independents, minor party candidates and major party candidates, even though the skew nationally will generally be more to the official opposition and the government of the day. But no, we don't go into the process saying, all right, we are mandating a minimum of this amount of minor parties or independents. That's why we run the Election Coverage Review Committee process during a campaign, which allows us to actively monitor how our coverage is travelling.
And with that, and I did hear your remarks previously saying that iCensure share of voice report is public, which is great. But is the Election Coverage Review Committee report or findings, is that also public?
Yes, it is.
It is. Okay, thank you. And I think I've looked at that in the past, so answering my own question there. Okay, can I go now to the complaints? Your submission says you received 396 complaints of bias in the 2022 election compared to 249 in 2019. What do you think led to the rise in complaints?
So it always flexes depending on the campaign and the issues and the mood of the electorate. So raw numbers, I think it's a mistake to read too much into raw numbers, and I wouldn't suggest anything other than there was a high level of voter engagement in the last campaign. There were issues that people cared passionately about, and so if they were unhappy about something they heard, saw, or read, they reflected that. It's still a pretty small number. We're talking about 500 or 300 or 119, depending on the category, but it's significant, and we obviously look at all of that feedback.
Thank you. Did you make any changes to editorial policy as a result of the complaints?
No.
Okay. Now, I think you've said that of the 508 editorial complaints received in the last election, that was the total, and 396 related to bias. What did the others relate to?
Unfair treatment, inappropriate content, sensitivity over the portrayal, I think were the other main headings.
Okay. And just reading
and accuracy, I'm sorry, accuracy, obviously.
Oh, yes, okay. Now, is it right that only a fraction of those complaints were upheld? I think I've got the stats here, 6% were upheld.
Yes.
And many of them were, many of the resolved ones went to accuracy. 4 of the upheld issues were raised into complaints about the same item of content and went to accuracy and impartiality. Would you be able to just tell us what the content, the subject matter is for that one, if you've got that to hand?
Yeah, I will just dig it out for you. Give me one moment. So, the issues were a Triple J newsreader inaccurately implying that Simon Holmes Court was the Teal Independent's main or only source of funds, a News Online story inaccurately stating that there is no Medicare-style levy to help pay for the NDIS, a radio segment that asked what political parties were promising to do about housing inaccurately stated that people renting in Victoria are subject to no grounds eviction, and an ABC sports story regarding the participation of trans women in women's sport included a section entitled "What Does the Science Say About Trans Women in Sport?" and that was breached on accuracy and impartiality grounds.
Great. Right, all right, thank you very much for that. Do you direct any additional resources to your fact check program during election campaigns, and what are the resources that are generally directed to the fact checking programs?
So thank you for the question. It's a pretty small unit. I can't give you a specific number of people off the top of my head, but it wouldn't be many, 6 or 8, something like that. And it really ramps up in election campaigns, and it had a very strong audience response. Viewing figures almost doubled, engagement times were up, and again, I know that the committee, one of the things the committee is looking at is truth in advertising, and resources for fact check, and the role of fact check services like RMIT, ABC Fact Check are very, very important during campaigns.
Do you see that, like we've had a lot of talk and a lot of discussion about implementing the truth in advertising laws, and this committee is charged with looking at that, and we'll consider the models and ideally legislate. Do you think there'll still be an ongoing need for those fact check programs, will it depend on the veracity of the laws?
Yeah, it will depend on the veracity of the laws, but I don't envy you your jobs here because, as you almost certainly know better than me, our laws were constructed to deal with traditional ways of publishing and mainstream broadcasting, but increasingly there is more and more activity online, micro-targeting, closed chat rooms, voter profiles being built, and all of that is extremely difficult to regulate.
Indeed. Well, we've just got the small jobs here, don't we? And last question from me. I'm interested in whether the ABC produced any election explainers
Yes.
beyond the excellent work of Anthony Green, how to register, how to vote, how preferential voting works, that sort of thing. Can you run us through whatever you did in that space, please?
So I can tell you that in the last election period, ABC News poured enormous resources into doing explainers and distributing those video explainers on social platforms to do everything we possibly could to engage with younger Australians, first-time voters, and they were literally explainers. I can't give you chapter and verse on titles and subject matter, but yes, we made a special effort at the last campaign to deliver more explainers, particularly targeting younger voters who are possibly less engaged in the daily cut and thrust of politics. But in saying that, I'm thinking about my own young adult children who might resent me saying that.
No comment. I presume, and I'm sorry, the audio is sometimes a little poor, so I actually just missed a few of the words there. I think you said they were videos that you produced.
Yes.
Can you tell me a little bit more about the placement of those videos? Because obviously not many young people watch ABC, and probably not many young people in the room right now. We all watch the ABC, but did you target them through programs like Hack or other sort of young people-centric programs?
So third-party platforms on social that they engage with. I don't have a specific list, but YouTube, Facebook and such, Instagram, I can get you more information on that if you would like. But yes,
yeah, thank you.
We recognise that, there are people who watch mainstream broadcast outlets, and there are plenty of people who are increasingly engaged online. And so this was a deliberate strategy to deliver useful explainers about the issues and the process to younger Australians where they choose to consume content.
Great. Well, really pleased to hear that. And yeah, thanks for providing whatever additional information you can about how you targeted that to your intended audience. And I think that's it from me, Chair. Thanks, Mr. McMurtry.
Thank you. Mr. McMurtry, I might just pick up on some of what you were saying around the fact-checking process there. As you said, part of what this committee is grappling with is the potential for truth in political advertising laws. And part of what's raised as a complication with us around that is the speed with which any type of judgment around truth could be applied. Could you talk us through the sort of fact-checking process, what's involved, how long it tends to take, so that we get a sense of what that looks like?
I think the best thing to do is for me to come back to you with a more detailed response, because it is quite elaborate. First, you have to select the proposition, then you have to identify, the sources that you are going to need to consult to test that proposition. Then there is quite an exhaustive vetting process that they run, because it's very, very important that the fact check is correct. That's why more resources and more effort goes into fact check during election periods. But my colleague Russell Skelton, who is the editor of RMIT ABC Fact Check, I'm sure is screaming at the TV right now saying to me, no, that's not right, more detail. And so I can go to him and we can give you something more detailed on that.
Thank you. I'll put that question on notice then. Senator Goodell,
Sure.
did you have any further questions?
No, just one thing on this truth in advertising. I think we had ACCC on before, also trying to avoid being the party responsible for gaining. Are we coming up with with this, however it's done, almost a third tier of burden of proof on this? We have, in criminal cases, you have beyond reasonable doubt. In civil cases, we have on balance of probabilities. If we go to this Truth Commission on advertising, are we really talking about feasible or possible, or are we coming up with a level of proof for advertising that is a third level that enables some things that may not be popular, some things that may not be true, but at least arguable out in the world? And does that create a problem?
So it's certainly the case that the freedom of expression is really crucial in a functioning democracy, and no one wants to constrain that. I'm not going to be very helpful to this committee in terms of paid political advertising and truth in advertising, because of course the ABC doesn't accept paid advertising of any sort, which is why I wanted to take you through the process we use for the free time spots, in case there is something there that might be useful. I do think it is particularly challenging to legislate effectively for truth in political advertising. That's not to say it shouldn't be done, it couldn't be attempted, but it's difficult.
All All right, thank you. Thank you for your attendance today. If the committee has any further questions, they'll be put to you in writing and you'll be sent a copy of the transcript of your evidence and we'll have an opportunity to request corrections to transcription errors.
Thanks very much.
Thank you. Are we good to keep going? We've got reset here. Yep, great. Let's keep going. Okay, I now call on the representative from Reset Australia to give evidence. For the Hansard record, can you please state your full name and the capacity in which you appear before the committee?
Chris Cooper, Executive Director of Reset Australia.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. And I'd now invite you to make a brief opening statement before we go to discussion.
Thank you. I'd like to thank the committee for their time and the opportunity to speak here today representing my colleagues at Reset Australia. We are a policy think tank and research organisation that addresses digital threats to Australian democracy. The integrity of our elections relies on a functioning public square, where voters have easy and safe access to an information ecosystem rich with balanced and truthful information delivered through transparent and accountable systems that are free from interference, hate speech, and algorithmic or corporate bias. In reality, our democracy has been rapidly accelerating away from this, most noticeably online, where the dominant digital and social media platforms dictate almost all of the content Australians are served. The business model of these platforms is one of rampant surveillance and data collection of the interests, vices, and vulnerabilities of Australian voters, which fuels opaque and often harmful targeted advertising and algorithmic recommendations that disproportionately amplify sensational, outrageous, and conspiratorial content to hold our attention at the cost of truth, balance, and social cohesion. In reality, the digital public square does not exist. Rather, we all experience an individually curated and personalised public square, creating echo chambers that drive polarisation, making democratic debate around a shared set of facts on the issues facing Australians near impossible to achieve. Voters deserve to know why they are being served a piece of content and who has paid for the targeted ads they see. And our democracy needs transparency and accountability of the foreign companies that shape the flows of information and public discourse during our elections. Without it, we will continue to see a slide in public trust of our democratic institutions. There is now an abundance of research and whistleblower testimonies that have exposed how some of these digital platforms have exploited an allowance of weak self-regulation to repeatedly prioritise their own profits over the interests of the Australian public, which is why we need regulation and greater oversight of the health of our information ecosystem during elections. Regulation that allows independent researchers and regulators to assess the health of the digital public square. Regulation that expands beyond content moderation to move upstream, focusing on the systems and processes of companies that create not only harm to individuals, but communities. This is regulation that enforces accountability and transparency of the foreign companies shaping our public discourse, putting the responsibility on those who profit from the harm, rather than placing the burden on individuals and communities. This is regulation that both informs and ensures adherence to their own internal policies of these companies. That doesn't stifle innovation or place unwarranted regulatory burden on our local tech sector, but rather incentivises what Australians want most: technology that improves their lives and strengthens democracy. I'm not naive to the policy challenge that this involves. The policy solutions require new approaches to reconfigure and strengthen the work being done by the excellent, albeit under-resourced teams at the ACCC, ACMA, the OAIC, the AEC and eSafety. But as the technology shaping our information ecosystems evolves, so too must our approach to maintaining the infrastructure in the public interest. We look forward to working with the committee and other stakeholders on this important work. I'm happy to take questions.
Thank you. I might get you to expand then when you're talking about regulation, about what regulation you think it is that we should be looking at. We've heard in evidence today about the voluntary code that's in place for the platforms when it comes to misinformation and disinformation. Do you have a view on that and how that operates?
Yeah, we've been quite critical of the voluntary code, in part because it is voluntary, and also because it's written by the platforms themselves and enforced at their own behest. And so it lacks the level of detail in their transparency reports, and ACMA made that explicit as well in their review, to say that there was inefficient data to inform or provide enough evidence for effective analysis. But also that we've seen the voluntary codes tried elsewhere in the world, in the EU particularly, who have now moved to a mandatory disinformation code that is, of course, crafted in consultation with the platforms, but as a regulator-led platform, has enforced a cohesive set of KPIs to ensure we're measuring what kind of tactics are being taken by the platforms, and measuring their impact and their effectiveness. Going beyond just the disinformation code, though, there is our focus really is on these social media companies and the regulation that's needed to ensure truth in politics, and we take a focus of looking upstream rather than focusing just on content moderation or moderation of sort of nefarious or malicious actors, to look at those systems and processes upstream and consider what kind of rules and regulations need to be considered in terms of, say, the algorithmic amplification of mis and disinformation in the first place. One of the challenges we've seen through our research in the election was that even though fact-checking is a critical component, it's been discussed at length today around the inadequacies of fact-checking. And we've seen that when we did an assessment of some of those fact checks on Meta during the election, that the amount of time that was taken to conduct those fact checks, the inefficiencies and inconsistency of the way that content was labelled or not labelled after being fact-checked to be false causes significant issues, but also the fact that while that fact-check process was happening, the algorithms were continually amplifying that content. So by the time that fact check is completed, these platforms have already served that content to tens of thousands of Australians, rather than, say, slowing it down while that fact check's being completed or introducing any sort of friction until after the fact. And even once that's done, there's no real oversight over how those decisions are made in terms of the reduction of amplification. And this is why we sort of call for more monitoring and oversight of these platforms overall.
So what sort of regime is that with more monitoring and oversight? Is that a body like ACMA looking at the platforms, or what are you suggesting there?
I think there needs to be a suitably qualified organisation that can analyse and report on social media activity, looking at the activity by parties, candidates, groups, looking at coordinated campaigns, the impact of sort of high-intensity accounts on public discourse, the use of bots, fake accounts, astroturfing. This is the kind of research that Reset Australia does, that we did during the election. And we are a small charity, and while the AEC did incredible work stepping up this year and doing more of that monitoring analysis, their scope is limited. And so it sort of leaves the Australian public with no one really looking at how mis and disinformation is being amplified, how coordinated campaigns between political actors and campaigning organisations are being run. And that seems to us always a striking moment when we realise that we're one of the few groups who are actually doing this work.
Some of it might be done by the Electoral Integrity Task Force, or are you talking about a separate space there?
So the Electoral Integrity Task Force, I mean, is something that we're very supportive of, although it's still somewhat unclear what exactly the terms of reference are for that group. In our submission, we've called for a similar sort of task force that would include representatives of the social media platforms and of civil society as well to potentially do this work, but to also have oversight and the ability to inform those internal policies of the platforms to ensure that they're actually adhering to their own policies around this work. And so there's different options, but that kind of task force is certainly a possibility.
Okay. And I might move then from misinformation and disinformation to political advertising. And as you're probably aware, one of the things the committee is looking at is truth in political advertising laws. Do you think there's a role for those type of laws when it comes to digital platforms, and how would they operate?
Yes, absolutely. I think there's a very great need for greater transparency. I listened to Digi's appearance this morning where they and the platforms themselves often profess the incredible transparency that's provided by their ad platforms. But if you ask any researcher or analyst who does this work to try and assess and draw data from those platforms to understand how political ads are being used or misused, they will all say that they're woefully inadequate to conduct that sort of work. So we call for an enforced comprehensive library of the political ads being run on the platforms. And that means detailed information about how each is being targeted. So that's really understanding that if there is a candidate who is running ads in different parts of their electorate or different parts of the country, we should be able to see how that's being targeted. That sort of access should be provided in ways that are actually useful to analysts. So rather than a clunky sort of manual platform, providing things like an API access to the ad library would help to speed up that analysis that can be done in real time by those analysts. And of course, this should apply to all platforms. There are dominant platforms, but we saw in the election, our research uncovered this, and it was reported in the media around political ads on WeChat, who have an internal policy of no political ads. And we know that wasn't the case. We saw political ads not only by candidates, but also lacking authorization as well. There's other components to, I think, truth in advertising laws that we think should be applied here as well, which is to go further on authorizations on digital ads to include a paid for by authorization to help voters better understand not only who's authorized this ad, but who's funding it. And that's really important, particularly as we see the rise of different campaigning organizations on all sides who often are coordinating or funded by politically affiliated candidates politically affiliated operatives.
Okay, thank you. Senator Cadell.
Thanks for coming today. It's relatively new. One of the things just raised some concerns. I'm not saying I'm against it, just first time I've really thought of it. You mentioned the ability to view ads in different areas, in real time, just in that answer, when, where they're running in different areas. If I want to letterbox an area differently than another letterbox, you don't see it. If I want to phone canvass an area, you don't see it. If I've picked up as a candidate or my party's picked up as a candidate, there's a different vibe after spending some money on research in part of the electorate. That's our comparative advantage. Why in digital should you be able to see that application of that research as opposed to other forms?
It's a good question. I think that there are plenty of other forms and mediums of advertising that does allow for greater scrutiny and oversight, that being the broadcast or other paid advertising. So there is a mix here. And I think the difference between some of those forms and the distinct, unique dynamics of digital advertising online is that you can reach a scale that we haven't really had access to before very cheaply. You can update them very rapidly. The ability for greater manipulation is higher than, say, in a letterbox campaign where you've actually got quite a process to design, print, distribute. That takes time, but you can do that within an hour on social media platforms. And so that increased reach comes with increased responsibility and ultimately transparency, particularly from candidates and parties.
Okay. And would you want to be able, just by geofencing geographical or by demographic and research points as well, or how would you like to see it?
So on Meta's ad platform, they provide a breakdown of targeting data by state, which is relatively useless. Google provides it by postcode, which is much better. And so it doesn't need to be down to the granular point.
If you had electorate, that would be more suitable, or?
Yeah, I think that's a start point. That's the relevant geographic boundary for an election, and that seems to be a more common sense position. I'd also say that the decision to provide that data by state level is a decision made by the platforms. There hasn't been that input from government or by the Australian Parliament on what those rules should be, and our focus is really on taking back some of those decision points away from platforms and making the decisions in this building, and that's a great one.
I think Digi and people today were talking about and it was somewhat persuasive, the ability of agileness of self-governing or codes of conduct versus legislation. How do you see that? Digital's a fast-moving world. I think it's like nailing jelly to the wall trying to keep up with it. Do you see a mandated code of conduct as opposed to a voluntary one being the best option, or absolute legislation, or what would your perfect world of outcome be?
I think the platforms like to make us believe that it's impossible to keep up with the innovation of tech, and there's an element of truth that they move faster than Parliament, but
can't move slower.
However, there are plenty of upstream policy interventions that can help to future-proof some of these controls. Also, placing decision-making powers with, say, those different working groups or task force. But if we look at, say, the EU Disinformation Code, which has been passed under the Digital Services Act, there's a number of components to that require platforms to make decisions upstream and hold them responsible for ensuring that they're not incentivizing the financial incentives of spreading disinformation, that they are held accountable for fake accounts, bots and malicious deepfakes, that they're providing greater transparency of political advertising. All of these components are upstream interventions that change the way the platforms operate in order to limit those downstream harms. Because if we sort of zoom out from the situation that we're sitting in, which is we're essentially left to pick up the pieces of the harms caused by mis and disinformation, most of which in our view is caused, of course, by malicious actors, but is amplified and enabled by these platforms who don't take responsibility for that and continually place responsibility onto the Australian voters to be able to navigate the information ecosystem that they've created and hold us accountable. And so there's plenty of sort of those upstream policy solutions that can be explored here. And in our submission, we've got a lot more.
And we're specifically talking about advertising, not content, being the more validated stuff. Because if I want to believe Chuck Norris is the second incarnation of our Lord, I should be able to go on and do that no matter.
Yeah, totally, you're right. However, I do think there are some important differences here, and of course, like freedom of expression is important. I don't think there's anyone who's been in here today that says otherwise. I would say a couple of things before I get to the political advertising side of it. Is that freedom of expression is critical to the function of our elections. However, what we're talking about here is not limiting freedom of expression. We're talking about the unequal treatment of different forms of speech from different people through that algorithmic amplification by the platforms. And so if your opinion on Chuck Norris is more sensational or outrageous, it makes it more engaging. It's going to reach more people because that's how the platforms are designed. They don't assess for truth or balance or anything like that. And so what we're talking about is leveling the playing field in terms of freedom of expression being more held to its core principle of speech being equal. And then on political advertising, we've done experiments to demonstrate the kind of lackluster, sloppy controls that platforms like Meta put in place to assess the ads that are put on their platform. And that's involved us submitting ads that, if they had gone live, would have been considered illegal and breach of electoral law. And we were able to get them approved by Meta's platform, and of course took them down before they went live. But we wanted to demonstrate that it is very easy to shirk and to get around the controls that they have put in place under their own sort of guided, voluntary, self-regulatory approach. And there really is a need for external oversight in order to bring that accountability to those platforms.
Okay, so just one thing. We're seeing in the US the potential banning of a platform if it wasn't, or more control wasn't brought on board. The US has and most of these platforms are based in the United States. We're talking about Australia or overseas. They have a very different political process. They have voluntary voting, so you see campaigns on the extremes to get out the vote, to motivate people to get out. Do you think that's one of the reasons these formulas, these documents try and do that in Australia? It's a very different political, where we're talking about persuading in the centre. Do you think that the hype is there because of a different cultural understanding, different political landscape?
I think it's certainly a factor, and I think that we're better off for having mandatory voting. It could protect us against some of that. Although we do see the ways in which our online experience through these platforms are curated based off our interests, our vulnerabilities, our vices that are identified by these platforms. And so we're still seeing the same polarizing effects of those echo chambers that are created, because there's still a pull towards the not only the more sensational, but the extremes on each end. And of course, I think Australians are a little bit more cynical and critical. And that maybe happens at a slower rate than in the US. I think there's a lot of other dynamics there. But that's in our view, one of the biggest threats to our ability to have the sort of messy debate around a shared set of facts at an election and disagree on those points when we could essentially experience a different set of facts because of who you are and your previous search history and who you're friends with. It makes it more difficult to find common ground.
So, last question, Matthew. Do we need more Australian onshore control of these things?
Absolutely. I think these are trillion-dollar foreign companies that dictate the majority of content served to Australian voters. That alone should be enough of a sort of warning of concern for us to take some level of control back in terms of ensuring the balance of the information ecosystem that Australians are immersed in.
Senator Brogan, did you have any questions?
Just a quick one. Your commentary has kind of vacillated from what I'm interpreting as strict control to not so much control. Where do you think the balance sits? Because obviously some of the issues, as you've outlined, are quite alarming, and how do you curtail that sort of behaviour without crushing the ability to provide any form of commentary? So do you have a sense of where the line sort of is drawn?
I think this is a question for, this is part of a bigger conversation that as a society and a democracy we haven't really had. I think critical and core to our recommendations in this inquiry and previous has always been around the need for greater transparency so that we can actually inform better policy, to assess where do we draw the line around hate speech online, around disinformation and where that becomes harmful. And we're actually ill-equipped to inform those decisions and draw those lines. And we at Reset Australia would not propose to be those who make the rules on that. We'd love to contribute to the conversation, of course. But there is a need for greater transparency so that we can actually really assess what is the state of the information ecosystem for the majority of Australians, to inform where that lies. There are, of course, some hard lines, which are things like hate speech, which are set out in our laws already, but aren't enforced on these platforms. We rely on their own community guidelines. And we've seen through our research that they are not, they do not adhere to those their own guidelines as much as they say they do. They are only really exposed to us being able to view the publicly available data. But when we've worked with other researchers who have gained access to private groups that are considerable in size, or to private messenger chats, where the amount of hate speech and threats to public violence are extreme, and there's no accountability around that content that does sit on their platforms. And so there are some obvious hard lines, but I think it needs more consideration.
Thank you.
Thank you. Any further questions? No. Thank you for your attendance here today. If the committee has any further questions, they'll be put to you in writing, and you'll be sent a copy of the transcript of your evidence and have an opportunity to request corrections to transcription errors.
Thanks very much.
I'll now close our public hearing, and I'll just ask members to stay on the line and in the room so we can deal with authorising transcripts. You stay.